Today's daily course list, delivery of order item 1.
1 and 2 orders will pass within the course day. You need not wait, Mr. Dispose that idea.
Item 326.
Good gole Manu. How?
Item 7. Item 7.
You are appearing for the private respondents. Nobody is there for the.
My lord, I'm representing, my lord, the respondent number 4 to 12.
What we have done, there was a similar, Mr.
Submitted by affidavit in reply.
Mr. Majumdar also. Under the Land Grabbing Act, yesterday I had told Mr. Nath also, there is a requirement for constitution of an appellate tribunal.
Yeah.
Unfortunately, in spite of repeated efforts from this court, the appellate tribunal has not been constituted. Mr. Nath told me yesterday that there is presently a move to constitute an appellate tribunal. If an appellate tribunal is constituted, why should we be concerned with this matter? Because that may not be the appropriate procedure also. So we have fixed that matter on 18/6. 18 June. If you also can use your good office and get, Mr. Nath knows about it. So we'll have it on the same matter on 18th again. Right? Let's see if an appellate tribunal is constituted, let that tribunal, why should a person lose a forum? Right? Mr. A similar matter was listed yesterday in the cause list, listed yesterday, and the matter pertains to constitution of an, the matter pertains to an appeal. A matter pertains to the issue involved in the present proceeding relates to an order passed by the, it's called a tribunal, by the special tribunal constituted under the Assam Land Grabbing Assam Land Grabbing Bracketed Prohibition bracket over Act 2010. So, the said act contemplates constitution of an appellate authority. However, the said appellate authority has not been constituted till date. Also, accordingly, list this matter also on 18/6/2024. Joakali ki kiman asil to item 2. Mukhe cause list to dilemma compom.
May I request your lordship, my lord, to indicate in the order to, my lord, direct us to obtain instruction as to whether the.
I've already done yesterday. I've done yesterday.
So that with the help of this order, my lord, we can.
I've already done yesterday. Not has it not. Has it not? No, it's 17, 18 is section 17, 18. I'll incorporate that. File to move Mr. Borua, can you just get that item number from Mr. Yesterday's matter? Just get that item number so I can connect it. We have fixed the matter yesterday on 18th and asked Mr. Nath, Mr. Majumdar is also here today, as to why the special appellate tribunal is not being constituted. So he said that there is a move underway, the process is underway. So we have fixed the matter on 18th. This also will come up on 18th and then let's see what happens.
In fact, there is an order of this on court.
I know that.
Converting this to insertion.
But there is no appellate tribunal. How can we revert it back? We'll have it on 18th.
Well,
that orders will pass, Mr. Having a slight problem in deciding how to undo something which is there for the last so many years. That's the only mental block we are having.
I understand.
It's otherwise an illegal order. But thing is that person has continued for around 10, 15 years now.
But I realize this Dilip Das case, it is a very
I know.
kind of authentic
We
case.
cannot shut our eyes also.
Where
Mr.
some observation is also made by.
We cannot shut our eyes also.
Yes.
Let's see what happens.
Also, it's item number 34 of yesterday's.
34, some we don't list 34. Early cousin. The issue involved in the present proceedings. The challenge involved in the present proceedings is to an order passed by the special tribunal. Special tribunal bracketed land grabbing. Goalpara. Under the provisions of the, against an order of the special land grabbing tribunal, Goalpara. Under the provisions of the Assam Land Grabbing Prohibition Act 2010. Also, in a similar matter, being WPC number 17153/2023 listed yesterday, this court had required Mr. D. Nath, learned senior government advocate, Assam, to receive instructions as to why the appellate tribunal as conceived under the provisions of the said act has not been constituted till date. Also, accordingly, we list this matter also on 18/6/2024 along with WPC number 7153/2023. Also, Mr. D. Mojumdar, learned additional advocate general Assam, who is present in the court today, has also been requested by this court to apprise this court on the next date fixed as to why the said tribunal is not constituted till date. We have also requested you in this order. Yeah. We have gone through it again. What we'll do is, we'll dispose of this writ petition, saying that now it's the government who is the authority to look after the provincialization. We will allow the school managing committee to submit an application before the inspector of schools, giving all details about their land, the land that school had, and which they now contend to have been encroached. Now, having done that, once that application is received by the inspector of schools, the inspector of schools will take it up with the deputy commissioner and take the matter forward. I think that way your thing is also done with. Disposed of. Who is appearing for the education department? Whose name can be put? Just write a slip of paper, anybody's name. Ms. Das, you are also appearing for certain respondents. Madam, you are also appearing? You're not.
3, 4, and 5.
You just write down a name of a secondary education council.
Item 24.
On last occasion, I was directed to,
Huh.
on last occasion, I was directed to write in the departmental pad by the departmental officer, madam. But I have communicated through mail as well as hard copy sent. They forwarded the letter, man.
Or you have not received it. You have not received the instructions.
Granted, so from New Delhi, immediately after getting any information, we done.
Heard the parties at length. List this matter again on when?
My lord,
When do you want it?
after 2 weeks. maybe.
No, 2 weeks is too much.
From New Delhi.
What is New Delhi? How
Madam,
much time does it take?
I don't have any problem, my lord. If they.
1
get
week. We want that instruction. 1 week. We'll have it on 18th, 19th.
I will tell you. I will-
List this matter again on 19/6/2024 for further hearing. In the meantime, Mr. E.S. Bhattchaji, learned CGC,
Yes.
shall complete his instructions in the matter. Let's see
Yes.
how we can help you out.
Okay.
It will letter to ready. Mr. Bhattchaji, you take back your letter.
Hearing item 8 to 15. 8 to 15.
Please, your lordship, my lord. I've gone through the cases, my lord, and there are the Rabha Hassan Autonomous Council, which was constituted by an act in the year 1995. Thereafter it was, this act was amended many times, and last it was amended in 2024.
24.
Yes, last amendment. I have given everything, and that
Give him a
section
copy.
4 has been,
In the amendment of 2024.
Hmm.
And the amendment of section 3, particularly section 4,
Hmm.
not here
the
anything.
village council concept itself has been done away with,
Village council, section 4 is omitted totally.
omitted.
Therefore, the concept of tribal subplain area is also gone.
May
Now,
I,
my lord,
sub-
what remains in this case is after going to the all main act, principal act and the all amendments, what ultimately remains is that no village, no tribal subplain area, no satellite area, nothing can be, no core area can be included in the Rabha Hassan Autonomous Council, which is not predominantly a tribal area. That I can show from the act itself.
may I submit?
Yes.
Only this morning I have got the files, I have to appear and represent. My lord, it's possibly State Election Commission will be a necessary party. Because as far as item 8 is concerned, lordship will find whether the petition itself is surviving or not, because the prayer was drop, exclude the 91 villages from the Rabha Hassan Autonomous Council area before holding the election of in 2013, this petition was filed.
That is a prayer he made at that point of time, but basically the thrust is that these villages should not be incorporated within that,
Included in the
Council.
Rabha Hassan.
basically.
My lord, and
So-
I have not gone through the petition. Let me go through the petition. Lordship can take a after tomorrow, my lord. I have not gone through.
No work for me today then.
My lord.
No work for me today. Yes, what is the, Mr. Majumdar, let me
Yes.
just understand this amendments,
Fine.
just for a second. So under 24, we'll not put you in trouble, we'll
Fine.
accommodate you.
I have no difficulty.
My lord, may kindly come to page 24 of that paper book. I have, by pen, I have marked the page number.
Hmm,
Come to 25.
hmm.
Kindly read amendment of the preamble,
Hmm,
section 2. May I read? my lord?
hmm. Whereas it is expedient to provide for.
Whereas it
establishment
is
of
expedient to
association-
provide for the establishment of a Rabha Hassan Autonomous Council within the state of Assam with maximum autonomy within the framework of the constitution comprising of the satellite areas and core areas for social, economic, educational, ethnic and cultural advancement of the Rabha and other scheduled tribes communities residing therein. The preamble itself says the function of this autonomous council is for the upliftment of the scheduled tribe people, including the Rabha Hassan. Now kindly come to next area. Next, amendment of section 2. In the principal act in section 2, for the existing clause Q, the following shall be substituted, namely satellite areas. Means the area or areas consisting of non-contiguous cluster of villages predominantly inhabited by the scheduled tribe population having 50% and above as a whole in the cluster and not necessarily in the individual villages. Now the Milord will appreciate. Now kindly Lordship will refer to the census report. Whether these areas,
Mr. Let's not jump into it. Let's first understand the act. You come to section 2 in the original act.
section 2 of the,
Which was amended now
yes,
in 2000, section, in the principal act, section 2,
yes,
satellite area and core area.
yes.
Huh?
Now
That
this,
was incorporated.
yes,
Okay. So now you say this was further amended in 2024.
no, this was not amended.
Then that continues.
Section 4 in 2000, yes, it continues.
Section 4, come to section 4.
Pardon?
Section 4, you come.
Section 4 is gone, Milord.
There shall be a village council.
Section 4 has been
Wait,
totally omitted.
one second. There shall be a village council for each block of villages, each villagers having 50% or more Rabha population. Each village council area shall consist so and so, so and so. So and so, there shall be as many as so and so. So section 4 in the original act conceptualized a village council.
Yes.
Now, was this amended at any point of time? 2001, 2005?
Now,
This provision of 4?
now,
Yes, in
by
2001,
24
it was,
amendment, section 4 itself has been omitted.
That's what I'm coming to. So now, section 4, the word Rabha shall be substituted
by
by
tribal.
tribal. And in 24, what they have done?
Whole
Whole.
section 4 is.
So, that village concept again goes.
Again goes. There's
So,
nothing.
satellite core remains.
Remains.
Okay.
So
Now,
that
what is
why
the
page-
further?
That is why page 25 is only relevant today.
Okay. Okay.
What I'm trying to show to your lordship is, whatever the meaning given by this amendment to the word satellite areas and core areas, the sacrosanct, what is sacrosanct is 50% or more.
You
predominantly
cannot, you
scheduled
show me that this satellite area means consisting of non-contiguous clusters of villages predominantly inhabited by so and so having 50. So what is your cluster, under which your village comes?
No, I have given in my writ petition what is my village and what is the.
That's not the cluster. It's not coming out from
This
any
is what I
document.
have to show what is the cluster, in which cluster my village falls. That is their business, Milord. Now kindly appreciate.
Now
what
see,
has to-
that village concept, which was watered down in the amendments prior to 2024, now has been done away with.
I understand that, Milord.
Then,
What is my respectful submission is, Milord,
now last around how many? This act came in 95, right? From 95 till 2013, you had no problem. In 95 till date, what is the problem you are facing?
because
Let's
of the
understand that also.
because of the notifications. By the impure notification, that is your lordship can. The list of villages, my lord. Notification of 20th February 2013. If lordship is taking up 3746, my lord.
What is that notification?
By that notification, our villages are newly included in the Rafa Hassan. That is why the cause of action arose.
Okay,
Earlier it was not there.
come to that. Where is that? Item number, we are item number?
My lord,
3745.
3746.
46.
Yes.
46 to some.
Page 37 below. Page 37. Is the notification by which our villages has been included.
Now this concept is gone, village
This
council.
concept is gone.
gone.
That is why, my lord. Now these villages cannot be included in the Rabha Hassan Autonomous Council, considering the latest development.
Now show me the provision here with regard to who has the power, who has been empowered or delegated the power to issue notification that which village will constitute.
This is the,
Up-
that is the government, my lord. If not,
Where,
you can-
where?
My lord may kindly come to page 2 of that paper book, my lord. I have given the compilation of acts, my lord. Section 4. And you see section 3, my lord. Section 3 of the Principal Act.
No, that is it. Where is this notification?
Pardon?
Where is this notification under 3.1? What you're showing me is a notification issued under 48.
That is what this notification.
So
cannot
there
sustain.
is a notification prior to this, which includes,
That is possibly of 18 January. Nobody has annexed this double.
where is that? That is
18
what I'm
January.
asking you from the day one. Where is that notification? Because this council concept, if you come to section 48, that notification that you have referred, 22/2020, 2013, is a notification under 48,
40.
section 48.
This is the delimitation.
Huh.
But the power of
but-
delimitation.
Mr. Shamuha, this delimitation would come into question once these villages are identified. It's delimitation for the council, village council. One village council will consist of which villages. But the inclusion in Rabha Hassan Council, Rabha Hassan Autonomous Council, how was that made?
Section
3.1.
3. Kindly see section 3.
3.1, where is that notification? You read 3.1 again.
Pardon?
Read 3.1.
Yes, madam.
There shall be an autonomous council to be called the Rabha Hassan Autonomous Council within the state, comprising of areas of village council as may be specified by the government by notification in the official gazette.
Yes.
Where is that gazette
That
notification?
is not there.
Then
That is why
where is your statement?
that is why this is
Where,
illegal.
where is your statement?
No, this is a question of law.
No, it's not a question of law. Where is your statement that this was never included by way of a gazette notification under 3.1? You are challenging a subsequent action. I did not have the acts with me. That's why that day I could not. Show me the challenge. Because this act is there from 1995 onwards.
That is page 37 of this writ petition. 3746/2013.
37,
3746.
page 37. That is a notification.
My lord,
That is 48-1.
my lord, yes. My lord, lordship will kindly see here.
Huh.
In between, my lord. There is a line, February 2013.
February
Then, my
2013.
lord.
Defining.
Proposed territorial limits of 17 constituencies for the General Council of Rabha Hassan Autonomous Council, Village Council constituencies falling within the jurisdiction of the Kamrup district.
Kindly come to paragraph
Now,
20 of my
my lord,
repetition.
now let us, my lord, pausing for a moment. If the village council concept itself has been done away with, then what is their cause of action today then?
No, I'm not on that.
My lord?
Village council may have been done away with,
Yes,
but that is 48 onwards goes, 50 goes.
yes,
But the inclusion
yes,
of these villages remain.
yes.
That
So
remains.
now there would be a Rabah Hassan council area. And within that area, we will ask, what is that Rabah Hassan council area?
This will.
Their village also would be identified. Now, for this purpose, you will have to refer to section 3(1),
Yes,
a notification in the official gazette by the government.
Yes, by the government.
Government means the state government. Now, where is this notification?
my lord, they have come at a very premature stage. That's what I'm saying.
No, Mr. Muzumdar.
Hmm.
The challenge here
Yes.
is to this notification, but
Yes.
also the issue is whether their villages could have been incorporated.
Yes,
Now, this challenge, technically, I can say that the incorporation not under challenge, notification under 3(1) is not under challenge. So subsequent actions you cannot challenge. I can close the writ petition. But the question is, once you have exercised your power at page 37,
yes.
it presupposes that these area will, or the areas, I'll call it the areas, are within the Rabah Hassan council area.
That's what I'm saying, my lord. That stage does not come. It is a stage of asking for claims and objections.
No.
My
no.
lordship may read.
You come to page section 48.
No, my lord, with 37, the lordship will read further, my lord, what
Huh.
it says. This last paragraph, my lord.
Hmm.
Claims, objection, comments, and views from political parties, various groups and organizations and individuals. So the draft, it's a draft. Delimitation order will be received by the Deputy Commissioner Kamrup during office hours from so and to so and so. Disposal of public representation, if any, will be done in due course, and interested political parties, groups and organizations received will be heard in person if necessary. The proposed list of constituencies for General Council and Village Council are annexed herewith. The proposed list of constituencies for General Council and Village Council are annexed herewith. So, my lord, after this, if there was no stay, whether this is proceeded further, this is one aspect.
No, you come to page 39.
39. Yes,
General council constituency has not been done away with, Mr. Somua.
I don't know.
It is continuing.
General Council.
Okay. Now, you see here, general constituency is Pantan. Right? Now, village constituency is Andheri.
Yes,
Now, within Andheri, delimitation is sought in this manner.
yes. It will remain in Pantan, General Council.
General council area. Now, you come to section 48(1).
Yes,
There
Yes,
shall
yes,
be 10
yes.
constituencies
yes,
in a village council area for electing members to the village council.
yes,
Each such constituency shall be a single member constituency and shall be territorial.
Yes.
There shall be 26 constituencies covering the council area
Yes.
for electing members to the general council.
Yes.
Each constituency shall be a single member constituency and territorial.
Yes.
The government shall, by order published in the official gazette, determine the territorial limits of the constituencies into which the village council area or the council area shall be delimited for the purpose of election of members to the village council and the general council.
yes.
Now you see,
Right.
this delimitation would be within a demarcated area, which would be the Rabah Hassan Council area.
Yes.
Now, where is that demarcation? Notification demarcating that and incorporating these villages. Because if we only go by this 27, tomorrow they can say the Kamrup Metro, 50% we are, this 50% from Maligaon onwards would be Rabah Hassan Council area, delimited in this manner. That cannot be. There has to be a notification under 3.1.
Well, I'm
You check up 3.1 also.
Well, I'm responding to this. Lordship will kindly see the 48 is a section meant for delimitation.
Only.
Now,
Delimitation for the purpose of election.
Well, finalization, yes.
Hmm.
Finalization of the area to be falling in a particular general council, let us forget about village council. General council will have to be done in the procedure prescribed under 48. Now, 48 subsection 3 is the culmination.
Hmm.
There is no final notification under 48.3. They are only saying that we are suggesting, this is a draft, that this area will now fall within the general council.
Okay, this matter is here from 2013.
My lord.
Basic grievance is,
Well.
this is our consequential, forget it, forget his action.
Yeah.
Forget his action. His basic grievances are villages below 50% or negligible or nil ST population. How can you incorporate? That is basically the question.
The only
I'm saying,
challenge.
well, this, what I am trying to first indicate is, my lord, this honorable court will not enter into that exercise whether it is falls within.
We'll not. We'll
But-
only say now,
Yes,
we
yes.
only want whether there is a notification under 3.1 incorporating, I'll not call the village, incorporating the area wherein this village falls within the, you come to 3.1.
My lord, I've understood, my lord.
Mm.
I'm responding to you, lordship.
Mm.
My subject to.
I understand. We are deliberating
Yeah,
only.
my understanding is, initially, when a particular council is defined, there will be a notification under 3.1. Subsequently, if. there
And
is a
Mr.
requirement-
Just interceding you for a minute. When that notification is issued,
My lord,
establishing a council,
areas
the
are defined.
area will also be
Defined.
in,
Area is defined. Now, if there is a requirement, madam, with the increase of population and with the lapse of time, and there is always an exercise of delimitation. So the delimitation procedure is prescribed under section 48. Now, once a process has been undertaken under 48, the normal procedure in such cases is a notification will be issued inviting claims and objections. Somebody comes and says that no, since in our area, the requirement of 50%, 40%, whatever it is not fulfilled, so we cannot be brought within the jurisdiction of the council. This is what is the basic prayer we use.
forget their prayer.
Yes.
What I have understood in this grievance is, maybe the formulation of the prayers may not be in the manner which it could have been better. But the core issue that they are trying to raise is that we cannot be placed
Well, this is,
in the Rabha Council area.
well, this is what I am responding to.
Ah.
my lord. Now, if there is a suggestion, now with this notification of 20th February 2013, claims and objections have been invited with a proposal that one particular area is sought to be brought within the.
No, it is already within the area. Now the village council will consist of so many villages. That is what is being demarcated
Then, my lord,
in this.
then, my lord, if it is already within that area,
That is what I'm coming
then
to.
their challenge would have been on the first day when it was
That
included.
is what I'm
Or-
coming to.
Or subsequently, if they find that now with the change in the population pattern, it can no longer remain within this, they may come up with a petition like that.
Unfortunately, in this writ petition, there is no affidavit from the government since 2013. DC has filed an affidavit, very sketchy, be that as it may. Only thing you got to bring before this court is that, see, there is already a notification
Right.
notified in the Gazette under 3.1 incorporating your villages. You have not challenged that.
Yes.
Now you cannot challenge the delimitation process.
My lord.
Just get that to me, finished.
Yes.
We'll dismiss the writ
My lord,
petitions.
this is absolutely correct, my lord. We'll find out that, my lord. Otherwise, my lord, if your lordship goes to the.
Otherwise,
notification-
Mr. Mujumdar, if you don't have a notification incorporating these areas within that Rabah Hassan
Yes,
Council,
yes.
how can you go for a delimitation exercise?
No, but it can be done. That's what I'm trying to indicate.
You come to
Suppose-
3.1. You come to 3.1.
No, my lord, let me complete. my lord. Delimitation is a process by which some areas falling within a particular maybe legislative assembly constituency. Falling within that area will go to some other area now. That is the delimitation, my lord.
We had a delimitation exercise here in Assam.
Lord, kindly bear with me.
Oh.
Lord. What I'm saying is, my lord, with the exercise of delimitation, areas falling within one constituency will go to the other. Areas not falling within that constituency may come within it. This is the delimitation process. Now, this process is undertaken by an exercise whereby the people of the locality who will be affected by it will be given opportunity to file their objections, if any. And after that, considering all these, they will come up with a final notification, and that final notification will be under subsection 3 of 48. And my lord, for that, in my humble submission, a fresh notification under 3.1 will not be required. Because 3.1 notification contemplates that initially when we constitute the my lord, council, we determine that this is the area which will come within the council, autonomous council. Now, after that, if any exercise is to be undertaken for delimitation, for changing in the areas, my lord, then a power is 48. And final notification under 48. Lordship, may kindly see 48.3.
Mr. Subjector, maybe I'm wrong,
Right.
but somehow I'm not
Right,
able to agree.
right.
Now, we had a delimitation exercise here,
Yes,
and the constituencies underwent change,
yes.
but no constituency went out of the state.
Out of the state.
State.
No, out of the state, you cannot go, yes.
So the constituencies that were delimited, where say if one constituency had 10 kilometers,
My lord.
today it became 15, another which had 20 became 15, five adjusted. So that is the adjustment going on within this territory of Assam.
I have understood, my lord, what your lordship is saying.
So,
Your lordship is saying that with the delimitation exercise, you cannot change the demarcation which was originally there.
no,
Within the
within that
council,
you
do
can
it.
change villages. You
My
can bring it.
subject to my lord, consideration by your lordship, my submission will be, so long as the exercise is undertaken within the state, territory of the state.
Because
This will be-
why I'm saying so,
My lord.
the concept of Rabah Hassan Council is not of contiguous villages. There has to be a definite application.
I'll find out.
When?
One possibly, my lordship may take it up tomorrow. Let me come up, let me read it.
Huh, tomorrow.
It's better.
Hmm.
If there is a
Tomorrow.
longer or bigger
No issue.
exercise is required, my lord.
No
we'll
issue.
see.
Then we'll proceed
Tomorrow.
tomorrow. Now we are into it.
Well.
And Mr. Majumdar is here, we'll be more emboldened.
I'll try.
But this, whether
Possibly. what
we,
your
I'm
lordship
not
is-
in the prayer, I'm exercising my 226 power. I'm not on the prayer. There's substantial relief. But if that area is notified at any point of time by the government, you have not challenged that.
Today,
Finished. That's the end of the matter, Mr. Chama.
I'll find out
Yes,
what is the.
I do
status.
admit it.
And without that notification, you cannot apply 48(1). There has to be
By-
that
by
area.
the- By the notification, what your lordship is indicating is, if in the original notification, the area is already included, any exercise to delimit cannot be challenged now.
Challenge now.
That I have agreed to me. If it was not originally included, now I am challenging the delimitation, there is no case for me. But it has to be in the first notification.
This will depend on.
That demarcation must be there while this council was
Just
created.
have a consultation with your people.
Madam.
Mr. Thor also can help you out there. Tribal affairs.
Or my lord, let us, if your lordship, so pleases, my lord, let us have it on next Wednesday. In the meantime, I'll find out everything.
No issue.
Because if some documents are to be obtained, my lord, tomorrow.
No issue.
it may not be possible.
No issue.
Next Wednesday.
Next Wednesday.
Tomorrow or Wednesday?
Wednesday.
Next Wednesday.
Next.
Sab, I'm at Mr. Majumdar's disposal whenever he wants it, because we want to know the facts,
Thank
the
you.
sequence. Now he'll find it out for us. You have not been,
I have not,
you have
I surrender.
suppressed that.
I surrendered.
You suppressed that.
No, I did not suppress, I surrendered.
Deemed suppression.
Somehow I couldn't go through the.
No, Mr. Majumdar, I just wanted what I understood to just convey to you,
Yes.
so that you can come back with a better answer.
Possibly this may be correct that once the area is not within the notification under section 3(1), delimitation exercise to bring in a new area,
Cannot be.
whether it will be permissible or not.
Just examine, but according to me, you can divide, you can add villages from
Within the area.
Nagaon to Kamrup,
Yes.
but you cannot give villages from
Itanagar.
Kamrup to Manipur.
Or Itanagar.
Itanagar. Lakhimpur would be a better example.
Earlier initially in the preamble, it was included Gwalpara and South Kamrup. In 2020, 2005, that Gwalpara and South Kamrup.
If this petition was filed today by Mr. Somuha, it would have been in a different form altogether. 13, we'll give him some
Yes.
young guy then. Adrenaline.
I
10 years,
apologize for the
reduce down the
mistakes.
lane.
And people learn from the mistakes. only.
That's not a mistake, mister. It's not a mistake. That is why we call it practice.
My lord.
And my lord, this kind of petition has many ramifications, and your lordship knows Mr. Chamua.
Ah,
So that also is a.
his future
Yes.
prospects may be in trouble. We don't want to put him into that trouble.
Now I will be in this soup, my lord. Obligation.
Mr. Mazumdar, please apply your mind to that. Heard the parties at length. Hearing remains inconclusive. List this matter again on Wednesday. Wednesday ki manta ekbo? Huh? 12. 12 for further hearing. We'll have it on 13th.
13.
Thursday, no, 12. I know, understand. Mr. No. There may be some other.
No, 12th is.
12th is
No
okay.
difficulty.
12. There may be some travel involved.
My lord, there's some familiar names I have already indicated.
For further hearing. এখানে স্লিপট পাঠাই দিব আপনি আইসে নি কোন মাতা
326.
Lordship, if I may, Lordship, can this matter be adjourned for today? Actually, the main Council B. Gogoi is having some personal medical emergency.
It was B. Chaudhary the other day.
And B. Chaudhary is also on legs, Lordship, in court number 13. There's a parted matter going on. I believe the senior is also the same, Sharaf sir only, Lordship. So if possible.
If you're not interested to do, you could have told me yesterday itself.
I understand.
On the prayer of the learned council for the parties, list this matter after how many?
Any
2
day,
months? 1 week, 4 weeks, 5 weeks, what?
So, Lordship, maybe a week, Lordship.
After 3 weeks, on a date to be fixed by the registry. Either patat korana hai main? Huh? But if,
Much obliged, Lordship.
Lordship, in this case, my senior has already completed his argument.
no, we wanted to hear the matter further.
Lordship, with the respondent council is,
We can't help it. We come prepared. If you're a guy, if you're not interested, you could have told me yesterday itself that we are not.
Lordship, we are not seeking adjournment in the matter, Your Lordship.
Whoever, somebody is seeking an adjournment, I can't hear halfway. Can I? Can I ignore them? 2 weeks ko video.
Item 16.
Here, my lord, last occasion of it, it was my lord,
Mr. Das, what are you waiting for? Mr. Das. Apuna. Item number? We'll take it up after this. Yes.
Please, your lordship.
Huh.
My lord, this is a land acquisition matter, my lord.
Hmm.
And on the last occasion, a report was sought from the deputy commissioner regarding the payment of the compensation.
Huh. Because the plea taken is that the money has been released, paid.
paid.
But you say you have not received it. Yes,
my lord,
particulars.
I'm told, my lord, that record has received by the office, my lord,
Which office?
taken up government office.
Okay. Mr. Raj, you're here? We'll take it up in the second half, 2 p.m. After 2, I have a video conferencing matter in Arunachal. After that, we'll take this
Okay.
up.
Lordship,
Mr. Dasgupta, you also have a same matter. Okay. We'll add 21 tomorrow.
21.
Yes. alignment of power.
Yeah, in this case, the Power Grid Corporation installed some.
It has
Tower.
already installed, it has put the tower, it has stringed.
Yes.
Now the current is passing. For the last around
8 to 10
8,
years.
9 years, what is the damage cost?
No, nothing. Look, so far, our contention is concerned simple.
Now
Prove
we
that-
can't ask them to now at this stage to ask them to now realign that whole thing because that may not be feasible.
No, one thing, my lord, actually, what happened is they have received the compensation, my lord.
That
They
you
are-
have written
No,
in
if
the
they have
affidavit
agreed by the compensation, my lord, they can approach the lot of districts, my lord.
because that provision is already there
16(3).
for enhancement of the compensation. Why don't you approach? We'll permit you. Because now you see, this lines with your photographs are not exactly on the top of your houses. It's going by side of your houses. Now for that right of way, you have been given a compensation. Right? Now, if that be so, if you want an enhancement of the compensation, approach the appropriate authority. We'll permit you. Because today, at this stage, after around 8, 9 years where there is
Yes.
further
that's
no-
correct. But one thing is that, Lord, we raised our objection at the initial stage.
I
And
got
the
it. I got it. Unfortunately,
Now, rule says that when there is an objection, it is the duty of the deputy commissioner to investigate this matter.
but here your
Not yet
allegation
done, has
is
not been done.
that even before the sanction was given, the right of way permission was already issued. Even before the authority had sanctioned the project or something to that, the deputy commissioner has given the no objection.
Well.
I think that is also a line argument you're taking.
That apart, Lord, we raised objection with regard to 2 towers only.
Even my,
To shift
at the
it
time
to
of-
the
my lord.
southern portion of our village.
Mr. Dasgupta, you make up your mind. If that be so, we can always direct you to approach the delay that has occasioned here. That is because you are proceeding the matter before
We'll
this
leave it to
court.
you.
You can always proceed before the competent authority for enhancement of the compensation, because they have said here very clearly in their affidavit that compensation was granted and you had received that, and that aspect was not denied by you. If I'm wrong, please correct me.
So I am only on rule 3B. May I pass it to you, Lord?
Kindly give me that.
I'm passing it to you. Oh, yes, I have incorporated that. Yeah, pass it.
From the photograph file also, which I have in it, my lord, this is a newly constructed, my lord.
No.
That's my lord.
I've seen, and there is a statement to that effect in your.
That we have said, my lord.
Rule 3B, Miller.
They will come up with this second proviso, first proviso. They'll come up
Provided
with
in
the
case
plea.
where the owner or occupier of the building or land raises objection in respect of works to be carried out under this rule, the licensee shall obtain permission in writing from the district magistrate or the commissioner of police or any other officer authorized by the state government in this behalf for carrying out the works, provided further that if any time the owner or occupier of any building or land on which any works have been carried out in support of the overhead land stay of start has been fixed shows sufficient cause, the district magistrate or the commissioner of the police or the officer authorized may order in writing direct any such work support stay start etc.
We got it. But unfortunately, we'll also have to take into consideration the financial public interest and the individual interest. Now, directing for a realignment at this stage would mean excessive cost and fresh proceedings. which may not be in the interest, because that lines which are carrying power is for all of us. And the only way I can help you out is by asking if you have a grievance with regard to the compensation already received, enhancement, there is a provision
16(3), my lord.
16(3) of the Electricity Act.
Of the Telegraph Act.
Telegraph Act, sorry. If you want some time to have want some time to think over it, Mr. Dasgupta, we can have it tomorrow if required.
Tomorrow, I don't have the contact with my client. That is the problem with me.
Happens. And Mr. Das, one thing, just for my satisfaction, there is an allegation level that the right of way
Right.
and the permissions
Yes.
were even given before the project was sanctioned.
Right.
What do you have to say on that?
No, about at the time of your making survey, my lord, at that time also there, nobody has objected, my lord.
So that is normally the procedure
But, my
followed.
lord.
Annexure B at page 42. my lord.
Annexure D, page 42.
Only 2 towers should be shifted to the southern portion of the village.
Hmm.
If it can be done now, that can be done, or if your lordship has indicated, that can be passed.
That you can proceed to for enhancement of compensation.
Hmm.
Telegraph Act to some. Telegraph Act. Telegraph Act.
18.
Hey, take it, you can do.
The annexure B was written by the village headman.
And there was the orders passed by this court also.
Yes.
One order I found that there was no interim protection granted. My Lord Justice Roy's order. Mr. So-and-so learned counsel for the submits that the concerned power lines were not only stringed, but were also charged, and the pleadings in the case are so-and-so, 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 so-and-so. So we'll not go into the issues involved. We'll only say a consensus has arrived at. And Mr. Das has also fairly submitted that in the event compensation has been paid, but if that is not satisfactory, a liberty be given to the petitioners to approach or we'll say that you want to approach, and he has not objected before the
So
jurisdiction.
far, my case is also, it should not be a consensus order. That may create trouble to the also.
Okay.
Hmm.
Let
Your
me
lordship
see.
may indicate.
Heard Mr. A. Das Gupta, learned counsel for the petitioners. Also heard Mr. Who is appearing for respond number 1? Give me a name of somebody, Mr. Item number given? 21.
21.
Now, senior government advocate, a senior advocate appear assisted by M. M. Devi, learned counsel appearing for the respondents number 2, 3, and 4. So Ms. U. Das appears for the respondent number 5 and 6. So the issue raised in the present proceeding by the petitioners pertain to the erection of towers and also stringing of electric lines in the area wherein the petitioners reside. So the petitioners have prayed for stopping of the construction of the towers involved and also thereby to prevent the respondent number 2 corporation from stringing electric lines over the said towers and charging the same. Also, it is to be noted that the towers and the lines pertain to high voltage transmissions of electricity lines.
So tower number 121/14, tower number 121/5.
More particularly, the petitioners have prayed for stopping of the construction of the towers number 121/4 and 121/5.
121/4, 121/5.
121/4 and 121/5. Also, the grievance of the petition with regard to the said laying of the electric lines pertains to the harm that would be caused, that is perceived to the members of the to the petitioners and their family members who have dwelling houses either directly under the said electric lines or nearby thereto because of the electromagnetic radiation occasioning on account of the high voltage electricity passing because of electricity passing at high voltage through the lines involved. Also, the Power Grid Corporation of India Limited had filed an affidavit in the matter and therein has contended that the petitioners herein had at no point of time objected to the setting up of the said towers and or the stringing of electric lines thereon during the time when the survey was so undertaken. It is further brought on record that the petitioners herein were all extended with compensation for the right of way involved, and the petitioners had accepted the same. It is also contended that the works involved were so carried out and concluded after the requisite permissions from the statutory authorities were required in the matter. So, it is seen that the stringing of the lines, that the setting up of the electric towers, the towers and the stringing of the line were all completed prior to 2014, and the same is in existence till date. Also, although Mr. Dasgupta had objected, had submitted that this court is now required to direct the Power Grid Corporation to remove the said towers from the plots of land of the petitioners herein, the public interest that is involved in the matter being overwhelming than the individual interest of the petitioners herein, and as contended by the learned senior counsel appearing for the Power Grid Corporation, that such an realignment at this stage may not be feasible, this court is not in a position to accept the contentions raised in the matter by the learned counsel for the petitioners. Also, however, noticing the provisions of section 16 16(3) of the Indian Telegraph Act, which mandate that in the event there is any dispute concerning the sufficiency of compensation to be paid under section 10 of the said act, comma, the disputing party may approach the district judge within whose jurisdiction the property is situated, and the adequate compensation can then be determined in such proceeding. Full stop. In the light of the above, in the light of the provisions of section 16(3) and also the overwhelming public interest in refusing to grant the relief as prayed for in the present petition, but however, to redress the grievance that may still be existing, the grievance the petitioner still may have, comma, it is required that the petitioner's hearing shall either individually or jointly file an appropriate application invoking the provisions of section 16 bracketed 3 of the said act of 1885 before the jurisdictional district judge, staking a claim for higher for enhanced compensation by bringing on record justifications for the same. Full stop. In the event any such application invoking the provisions of section 16(3) is filed by the petitioners or any of them, comma, the jurisdictional district judge shall consider the grievance so raised in the matter, and after hearing all concerned parties, including the Power Grid Corporation of India, shall dispose of such application on its
Fix the-
merits.
Fix the compensation amount.
Huh?
Fix the compensation.
Shall dispose of such application on merits and determine as to whether the petitioner, and after determining and if on a conclusion reached that the petitioner's hearing or any one of them are entitled to an enhanced compensation, shall direct for release of the same in accordance with law. Full stop. In the event any such application is so filed and an issue of limitation the issue of delay in filing such application so arises, the learned district judge shall, while condoning such, for the purpose of condoning such delay, take note of the fact that the issue involved was pending before this court since 28/1/2015 in the proceedings of the present writ petition. Full stop. It is needless to say that in the event any such application is so filed and the matter shall be given an expeditious consideration. However, only after providing to the affected parties an opportunity of hearing. With the above observations and directions, the writ petition stands disposed of. I think.
This project of 2014, not prior to Malo. That's somewhere you also mentioned Malo, prior to 2014 Malo.
No, prior to 2000, when was that stringing done? 2015.
Okay.
Huh?
It was a project of 2014 Malo.
Now, when was it that stringing done?
In 2014 itself.
14. Completed in before 2014 question, completed in the year 2014.
Right.
I'll correct it, don't worry.
Right.
Seventeen.
My senior legs in another court.
Who is your senior?
Mr. S. Islam.
SS?
S. Islam.
SS. Call him. We'll have it.
No problem.
Who is for the insurance company? Insurance company? Okay, you call your senior.
18.
With your lordship, This case is regarding non-payment of dues of amounting to.
You were not here. Nobody represented similar matters were here. We have disposed of all.
Yes, Lordship.
Same order.
Same order, Lordship.
You file an application, you make an inquiry. Because in your affidavit, you have said that he is entitled.
And that.
Then-
Lordship.
RCC के सर्व matters in लग रहा हूँ. Is there our AAY or MMAY similar order? Dispose of it. এটা একটা মঙ্গলারি বলতে হবে end তাত লিখি দিব you does.
1920.
There was another matter today that appellate tribunal. We have fixed it on 18th.
19 and 20.
Mr. Monto seems to be too angry today. Why?
No, that's all.
Be careful.
My lord. Otherwise, my lord,
My lord. Yes.
Yeah, I've gone through it. You take your seat. We'll first hear Mr. Bhuyan. Yes, Mr. Bhuyan.
my lord, the issue is very limited, my lord. The answer scripts provided by the APSC.
You
they-
first satisfy me on one issue, then we'll go into the merits.
Well.
I had a note. Where did I lose my note? Advertisement is of 2013.
13.
Results of the preliminary on 6/2, right?
6/2/2014.
You were given the RTI application, RTI reply on 31/3. You did nothing. You sat over the matter, right? Similarly situated persons come before this court. On 17/6/2014, the court disposes of that writ petition, limiting the participation to those petitioners, right? You did not come up. You were still waiting. First writ petition. Results declared on main exam 28/6. Results declared in May 2015. You instituted this proceeding
January
on 28/1/2015.
15.
By that time, the
Everything. finished.
process was over. Results may not have come, but the process was over. This court did not give you any interim direction, could not have given you. Because you can. Now tell me, how can we help you out?
My lord, regarding the delay,
And one more thing. Today, if I accept your prayer,
my lord,
I'll have to hold you qualified in the preliminary examination. Next would be directing them to rehold an examination of CCE 2013. Then to see whether you pass. Then to ask them to hold an interview. Then to appoint you. Now to appoint you, maybe there are vacant posts now after those people have been terminated. But where are those people who would be affected, made parties here? Now you satisfied.
consequences are so large, my lord.
Huh?
Consequences are so large. And the questions, my lord, coming from my lordship, my lord, is also very, my lord, it needs some time to satisfy my lord.
No time. Mr. Bhuyan is always before us. We just wanted to cut short the time, that's all. Now tell me what I can do for you.
But admittedly, the answer scripts, my lord, basing on which this.
We accept that, and they themselves in their affidavit say we are accepting that. But
But my lord, the relief.
operation
my lord,
successful, patient dead.
Lord, what I'm fairly submitting before my lord, my lord, is that the relief, my lord, which we were asking for, my lord, it is very difficult at this moment. to provide.
Cannot be.
Very difficult, my lord. Because those, it is a case that I had missed the bus. Now, my lord, the.
You were a fence sitter. You waited.
fence-
Because why I'm telling you, you knew about this discrepancy.
What?
I can infer that on two ways. One, your statements in the writ petition. I'll forget that. I'm not interested. You had this thing in your hand, answer key and the
Yes.
question, as of March 2014. You did nothing.
Correct.
And if it was to be considered today, this issue, the law of the Supreme Court, if you don't have a power of re-evaluation, this court cannot grant you. I think I passed an order in the division bench also.
But my lord, it will be an amount to allowing the illegalities to perpetuate.
It's not that you have not assailed the illegalities at the time. You have not raised your grievance. You have allowed that to go ahead. Now, once you have allowed the process to go ahead,
Not, I could collect from the pending cases before the summary.
no, forget the pending cases. You had a grievance, you should have come up immediately.
That statement I have made, my lord. That statement I have made. My lord.
Because I would have understood if you did not have this information.
Yeah,
But
yes.
you have categorically in your writ petition stated that it's more than categorical. That I got this on March, and therein then itself I came to know about this illegality committee. What more is required? And we cannot put the clock back today.
Some compensation amount they can pay to me, my lord, for the manner in which I have been ousted, my lord. The damage caused to my career, my lord.
It's not a damage caused to your career. You are otherwise an intelligent person, an intelligent boy. It reveals with the marks you have scored. And naturally, you did not have any backing, admittedly. Otherwise, you would not have had this position. 2013 selection, what it was. You are not the blue-eyed boy.
Lord,
Without being a blue-eyed boy, you got so much marks. Credit goes to the boy.
Lord, I even feel lucky because those 2013-14 batch,
Facing the police case now.
my lord, is now subjected to an inquiry, my lord.
Subject to the inquiry.
Subject to
lucky enough.
inquiry, my lord. Those 2013 and 14 batches.
All are, my lord.
My lord. And one man in.
I am online. Otherwise, I could have told you many things.
My
So, Mr. Bhuya,
my lord.
let us give it a closure.
Right.
And who is appearing in the second one? Naman Doctor? Oh, Mr. Sen, you are appearing. Same fate. Can't help it today.
Only thing is that, my lord, I have got, my lord, 8 marks short. My lord,
You are 8 mark shots. He's getting 12 marks.
10 marks.
Mr. Bhuya is getting 12 marks.
My lord, only question, my lord, here, my lord, the career of the, my lord, the candidates. My lord, that has been.
If
spoiled,
you
my
were
lord.
not a candidate for a combined civil service examination,
My lord,
maybe I would have thought something. But you are the cream. You are trying to get into the cream. You should be aware of your rights. Otherwise, how do I expect you to protect the rights of the others?
it's true, my lord.
That is what I have,
I agree, my lord.
for my satisfaction, drawn a conclusion. This is for me. I'm going to dismiss it. So I should also be, my conscience is also to be satisfied. This is how I have done it.
Correct.
You knew about your illegality committed to you. Why did you not react immediately? You should have reacted immediately. Yes, Mr.
My lord, after 1 year they came, my lord.
Forget it. They came.
Yes.
No, what
My lord,
will you
they
do
are
for
willing
them?
to set aside the select list. That cannot
That
be
we are
done.
not accepting, but
That
what
cannot
will you give them? Admittedly, you have denied
Yes,
them.
that is in the, I have seen that affidavit file.
So how much compensation?
That, my lord,
You have admitted to that.
because affidavit, I am, at that point of time, I was not there.
Whoever it is, they have,
Yes.
your authorities have admitted to that.
My lord.
At least in Mr. Bhuya's case, I have seen.
No,
You
no,
have said 12 marks is due to him. How much? He has been denied an opportunity. A fair consideration.
and
His
that
fundamental
point of
rights.
time, my lord, that your lordship.
How much? How much? You
30
tell me.
My lord, it is as a token, because at that,
Not token. That should be
because these
something.
persons are gone, my lord, they are facing criminal cases, my lord.
Let them
Those who
face.
has committed
Let
this
them
wrong, my lord.
face.
My lord, in a similar case, this honorable court has awarded compensation, my lord.
Compensation, but my lord, I cannot concede.
Show me. I'm only on that affidavit, that paragraph.
My lord, I have seen, my lord, yes.
Paragraph 7, my lord.
APSC.
APSC case, my lord. That is a 2015 CC, my lord. And case was instituted in 2017, my lord.
It is thus.
Basic health test.
Rishikesh Das, yes. Mr. I have also
Wait,
relied
wait,
on
wait,
it
wait,
from the
wait,
same
wait,
data.
wait, 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 wait. This boy was given tax, right?
My lord.
Where is that compensation?
Lord,
In some.
Here no compensation is given. He was given the post
My lord.
my appointment, yes. my lord.
because there was a post kept vacant for him.
Yes,
And see,
There is an interim order.
no, no, no.
There is-
This boy had gone up to the level of, I think, in written examination and interview.
Yes.
It is in some other case. I'm
No.
sorry, my lord, it is not here.
My
my
lord,
lord.
here you
Not-
know, so
not
kindly see,
Rishikesh
they,
Das, my lord,
applicantly
it-
they oppose after 1 year after getting reply, my lord. On that, my lord, that count your lordship kindly see, that means a preliminary, my lord. They
Okay.
cannot-
That all right, my lord, but
And what-
your
so
But
they can-
Mr. A.R. Bhuiyan, bottom case today, 5/22/2015. Mr. A.R. Bhuiyan, Learned Counsel, appearing for the petitioners, and Mr. T.J. Mohanto, Learned Senior Counsel, appearing for T.J. Mohanto, Senior Counsel, assisted by Ms. P. Das, P.P. Das, Learned Counsel, appearing for the Assam Public Service Commission. Ms. U. Das appears for the state respondents. Hearing concluded. List this matter again on 14. 14.
after
6.
vacation, law,
Finished. You're freed. It's my headache now.
my lord.
14/6. No, 13/6. 13/6 for delivery of orders.
No, that-
Same order, a 3184/2014.
and
Khali,
14, my lord,
huh?
14.
14.
For 13,
14.
I have a minute.
14. You need not be here. Send your junior. That's all. If something required, I'll ask for more.
My lord.
খালি ইয়ার নাম বিকে সেন্ড করে দিবি 14 দুটাই 14 একে অর্ডার হবে এটাই অর্ডার
My lord, nowadays, my lord, even in the carbon copy, my lord, the OMR sheet has been given now from this. From
because this
Yes.
Mr. Bhuiyan, this episode
Let me finish.
the public should be thankful to you and the others who had come up before this
Yes.
court because you changed the course of the examination conducting process by APSC. Now they, after that, from 2014 CE, they are uploading the answer keys
And not only that, from this year, my lord, you will getting the OMR sheet carbon copy immediately.
immediately.
Immediately, man. There is 2 copy, carbon copy, they can take away to home. Now,
What
it
will
from
they
this
do?
time. So that, my lord, it is nowadays, it is not difficult, my lord.
So no hanky panky.
OMR sheet, my lord.
No
you-
hanky panky will happen.
My lord.
No hanky panky will
No hanky
happen.
panky.
A lot of reformation has been done.
This time, my lord, OMR sheet, there is a
Immediately.
carbon copy, carbon copy take away. So you cannot.
Answer key you get.
Yes, answer key immediately upload, my lord, you get it. But entire result will be after completion of the entire process.
That's.
That is.
So now they did not
Now,
apply.
but try to, my lord, clean up everything. Now it is almost, my lord, complete. So
Human nature cannot change.
That is there, my lord, yes. you
My
are
lord,
not seeing- you
I
are
cannot
not
see
seeing
my
it
lord,
correct.
recording, that's why.
Forget it.
Highly obliged,
Yep,
sir.
yep.
Highly obliged.
Right, please, Your Lordship.
Yes, Mr.
Well, this is a
LA.
land compensation matter, my lord,
Mm.
pending since 2015. My land pending since 2015.
But here the land was utilized admittedly a ideal project lot.
Mm.
But here in the month of April, the Karbi Anglong Authority, they have submitted a joint verification report. But in the joint verification report, some information has come. Out of 233 bighas of land, the verification report now says that 94 bighas land has been affected. Otherwise, in the 62 petitioners.
Submerged area, that area's lands would be submerged. Then,
And my lord, in the writ petition, otherwise, petitioners are 62 petitioners and they have total 600 bighas of land.
Hmm.
Otherwise, the affected land is 94 bighas. But in the joint verification report, my lord, there are some discrepancies because the patkas are issued after the land was given to us. 233 bighas of land. And the classification of land, the details of the petitioners, those are. So, my lord, instructions on the joint verification report, the authority. No, I'd like to bring it on.
what was this? This was an 11 proceeding or the proceeding under emergency,
No, don't.
normal acquisition proceedings?
No accusation is there.
No acquisition was there.
But
Okay.
we requested the Karbi Anglong Authority for allotment of government land for the project. And they have allotted us subject to payment of some allotment fee. Now, my lord, in that letter, in 2006, the allotment fee has been set, posited. One sentence, if some persons are affected, then we have to pay them compensation. One sentence is there. Otherwise, we have sought for the government land and they have allotted us the government. So
Now,
now,
what would be the effect if you told me that the petitioners jointly have around 600 bighas?
yes, my lord, 600 because they have given us 232 bighas in land of.
That's what I'm saying.
In total.
So how come the petitioners 600 bighas is now in dispute for compensation when you were given 200
32
and
bighas,
you say that the joint verification report is with regard to 94 bighas?
94 bighas. Right.
Why this discrepancy?
No, no,
We are not paying.
Actually, we have not utilized the entire land of the petitioners. In fact, I would submit, my lord, that
You return back the lands which are not taken over. Madam, what is the document to show that your land was taken over?
My lord, lordship will
Nothing.
find annexure B, the allotment order,
Annexure,
B.
page. And this process, according to you, Mr. Nath, started in 2006.
allotment was
There is a
given in
bunch of
2006.
paper.
Huh?
There is a bunch of paper I had submitted earlier, my lord, lordship will find it convenient to see.
Ah. Page,
In writ petition, it is my lord 524. If lordship goes through the bunch of paper, my lord.
bunch of paper where it is.
A separate bunch of paper, my lord.
This one?
I think so.
Then where is that?
Writ
Which?
petition, I think.
No. This is seeking more time. Vidya Singh, Hanse and 61. This is a writ petition. You have given a list of dates.
Yes.
There, my lord, 524, page number. So I have made a small, the bunch of papers.
So this is saying Tozi revenue. That means that is government land.
Government.
common land, but another letter is there, my lord, but we are occupying that land from since time immemorial. And the- there is a customary law that land record, land documents were not given. When necessary, then only it is given to the petitioners, my lord. There is a letter, my lord. Lordship will find.
But, madam,
Yes,
now this says that they were given
if lordship.
233 biga.
33 bighas.
Total land.
So now Mr. Nath says your whole writ petition
No.
involves around 600.
For 600 and we are claiming compensation for the affected land only.
The affected
Why
land
600 came, I do not know.
from what is your affected land?
Yes, they are.
Now show me which petitioner is occupying how much land? And where is the corresponding land record? Otherwise, it says Toji revenue. Toji revenue means common land.
Lordship may kindly go through the, my lord. There is an extra, my lord.
I think, Mr. Nath, you complete your exercise.
Matlab,
We'll not rush into this.
page, matlab, 524, Lordship has seen. No?
Huh.
524, there, the condition is, matlab, the
Subject-
authority of Karbi Anglong Autonomous Council is pleased to allot land measuring 233 bigha, it will be bigha, matlab, 1 katha, 5 lecha,
Hmm.
adjacent to so and so. And for construction implementation of mainframe small hydroelectric project, 9 megawatts subject to payment of land allotment fee that
And-
we have paid. And clearance of Toji revenue annually as fixed by the council from time to time. The last line, my lord, the APGCL shall liable to pay compensation to the affected people, if any. That is the line, my lord, sentence, my lord. Now, my lord, the deputy commissioner, they
Have you
have,
installed this project?
it is what,
It's working.
and power is
Is
coming, my lord.
production.
And the deputy commissioner has assessed the another difficulty I am expressing, my lord. He had rupees for 233 bighas. Whereas the joint inspection report says that 94 bigha, if lordship kindly takes up the affidavit filed by the Karbi Anglong authority. 94 bigha is the affected land.
Karbi Anglong authorities, respondent number?
Karbi Anglong, they have filed kindly. The report will 632, page 632. my lord. Annexure R1, 632. Their respondent number 2. 630 it starts.
Hey, affidavit ki tarif.
Lot.
Six 32.
632 is the report. I'm just take your lordship to the 634, page number 634. my lord. The last column is total land affected. Total land affected.
Hmm.
So the total land affected is 94 bigha, 1 katha, 4 lecha.
Hmm. So is the names of the petitioners here? Have you made that exercise?
42 petitioners are here.
42
Out
petitioners.
of 60, out of 62, 40. 42 and 20 other persons, other affected persons, according to that.
Hmm.
So in fact, the joint verification report,
So out of the allotted land of 233 odd bighas, only 94 bighas Karbi Anglong Council says that people are being affected. That last line is to be applied.
Affected.
Right? And out of that, you say 20 petitioners would be involved.
42 petitioners are
42 petitioners are involved.
20 others, 20 others.
20 will not come in.
Got it.
So out of this 96, 42 are petitioners before
Petitioners.
this court.
Got it. And
Now, what have you decided with regard to this 94 bighas?
here kindly see, my lord, year of issue of patta. It is very relevant, my lord, page 36, 32, if lordship takes up.
Hmm.
Lordship will see the pattas were issued after our allotment, my lord, kindly see 2020, serial number 8, 2020 patta was
83
issued.
and 84, 2020.
2020, serial
What
number,
is the justification of the Karbi Anglong authorities in this connection?
there is nothing.
Who is appearing for the
My
Karbi?
lord, serial-
Yes,
Serial number 9, kindly see,
Huh.
2021,
21.
21.
No, it's there.
Got it.
13, 14,
Yes, yes.
15. Yes. Council,
And these are all annual patta.
Hmm.
These are all annual patta.
annual
And-
pattas, not the Miadi patta.
Very patta, nothing.
Pattas are annexed with the deed petition.
But
Lord.
in that case, in case of annual patta, if at all, they will be entitled for zirat. If they have
Something.
some corpse, they will get the value of that. But the nature of possession, it is also very important. Otherwise, Lordship may kindly just take note of that. The land is in a hilly terrain, alongside the river, because the Hydel project, it is in the midst of some hills. But agriculture and how they possess this land and what loss they have suffered, it is also an important factor.
Because it's not a case of submergence.
No.
So that's what I have asked you first, whether it's a case of submergence, that they fell within the area by where the dam was built and the submergence of the lands, their lands were submerged in water. So that seems not to be the case here. Because if they have been issued an annual patta in 2020, the Hydel project was much prior to that.
Lordship,
Yes, Council, what is your stand on this? How are the persons who have done this joint verification?
Lordship, the authority of Karbi Anglong Autonomous Council and the authority of APGCL, Lordship.
our officer also.
Joint verification report, Lordship.
In fact, the petitioners are also there.
Yes, Lordship.
Petitioner, they are also there.
Petitioner are
No, I don't understand. What is the nature of, how are these people who have been incorporated here affected? Why I'm telling you, if that land is not there, land is gone, that is affected, that is how they will be affected.
Yes, yes.
Their crops gone, their house gone, everything gone. Now, if that be the position, how can the annual pattas be issued on that very land in 2020 and 1921, 2002?
That had Lordship has to see.
How can I see that if you don't tell me? Yes,
They have.
that I have to take instruction, Lordship.
why? And Mr. Nat, your people are also there.
Yes, my officers are there.
So how have they come to this conclusion?
My officers, they are in their presence, revenue authority, they have said that this is the land we have measured. If he is the affected person, kindly see, only suppose number one, Hemari Rongpal, he is Hemari Rongpal, son of no resident of nothing.
Nothing.
No documents are there.
Now, why did they accept? Why did they sign?
In fact, the joint verification report, which a draft copy was given to us, that contains the nature of land, tag number. But the final report, which has been placed before your Lordship, it doesn't contain it. And one of the officers at local level, one of the revenue authority, they said you sign it because we have to file it before the court.
And it was said that to be submitted before this court for taking necessary action. How can we take necessary action now? Correct me if I am wrong. Land affected for the purpose of acquisition would mean that you have lost that land. Or the land has become rendered useless. Or it was not your land, but you were occupying that land and you had plants, you had very costly plants, maybe chandan trees were there. Maybe there was agar. So you have to be paid compensation. Now, once that project is implemented and the land is gone, how could you in 2020, 2021 give an annual patta to that very same land? That land is gone. That land is government land. How could you now again settle that? If you have settled that land, why is he entitled to compensation? When will you give me that instruction? Tomorrow?
Sir, after 1 week, Lordship. Next week, Lordship.
Okay.
Lordship, one thing, Lordship,
Hmm.
Lordship, bear with me. There is an order, my lord, letter to the Commissioner and Secretary, Government of Assam Revenue Department, issued by the Deputy Commissioner. Background of the case is there, my lord. Annexure C, page 529 of the deed petition.
529.
Yes, I have annexed the land document with the deed petition. It is a huge deed petition, my lord. writ petition. Entire background of the case is there, my lord.
I'm not on that.
I pray-
That there is a joint verification report submitted to
Yes,
this court.
So far, joint verification report is there, my lord. Petitioners were not called for, they were not there.
Okay, let us forget the petitioners.
Yeah,
But
but,
once you have that copy,
oh, yes, one report.
now, madam, if I have understood it incorrectly, correct me. Once a plot of land is acquired for some purpose, that plot of land becomes of that purpose. It cannot be for anything else. And the person is compensated because he loses that right,
Yes,
right?
yes.
Now, once that land is gone, how could an annual patta be issued in respect of that same land in 2020 to you?
That will reply by the comment.
No. You are the beneficiary.
Petitioner, we are only 60 persons, petitioner before your law.
Here, we hear any petitioner here within that 20.
Petitioner, my lord.
No. Who is the petitioner here?
Contain my lord 90 people. How can this?
No. 90 people, he says 42 are you.
42 are me, yes, persons whose land had been due, they were not before the committee and they are not included. We have filed the objection. We have filed.
So you also dispute this
Yes.
joint verification. You get your instructions. On the heard the learned counsel for the parties. On the next date fixed, Mr. Nath, learned senior government advocate, who is appearing for APDCL?
Well, here for APGCL, I am appearing.
Mr. Nath, learned standing counsel, AGCL,
APGCL.
APGCL, and Mr. Ronghang, H. Ronghang, R. Ronghang, learned standing counsel, KAC, shall receive instructions as to the manner in which in the joint verification report dated 1/3/2024, available at page 632. Available as Annexure R1 to the affidavit filed by the Karbi Anglong Autonomous Council on 12/3/2024. The persons named therein were so identified and as to how in a land already stated to have been acquired, pattas were issued to the person so identified as beneficiaries, were issued with pattas against the land acquired in their respective cases, even in the year 2020, 2021. Full stop. The said instruction be produced before this court in a form, the said instruction be placed before this court by a competent authority of both AGCL as well as KAAC in writing.
Well, APGCL may not be in a position to say, Lord,
Because your officer was there. I want an answer from him. That officer was there. You were there. We cannot absolve you.
No, well, the year of issue of patta, this is the revenue authority. They have
That is why he incorporated that. Let him say that this was as per the,
Lodge.
that much at least we will want.
Lodge.
When?
After 1 week.
1 week. List this matter again on 19. Hobo na? 20 kori 20. Boro? 20. 26, 2024. Madam, 26, 2024. And at a line later, the said field verification report is also disputed by Ms. P. Burman, learned counsel appearing for the parties, for the petitioners.
Much already.
Just for our knowledge, let it be there.
they have already filed an affidavit to that.
that they are disputing it.
No, they have said that some petitioners were not informed and done. Otherwise, on merit, they agreed that yes, these are the affected land, pay us.
She has disputed before me orally, so I have put it down.
Logic.
Masud.
If they are entitled, we will give. Whoever is entitled, we will give. But first show me that the land was lost.
Affected land, the amount of affected.
233 boils down to 94. So what happened to the rest? And 94 pattas, at least 30% or 40% people there, pattas in 2012 and thereafter.
Well, assuming it is correct, then also Lordship has to see the nature of effect, how they are affected.
That is also, full stop. The authority shall also, in their written communication, indicate as to in what manner the persons, 96 persons involved in this said report were affected on account of setting up of the project.
That will be fine.
That's all.
Thank you.
Item number 16, your lordship, please to pick on Act 2, madam. This report I have received, madam, but in this report, my planets no
Mr. Das's matter.
Here we have, here is a noting, madam, regarding receipt, but received by the person.
Have you gone through the records minutely?
Yes, madam.
You have gone through.
Receipt record, madam, there is a noting, madam, that finance
Mr. Das,
award
go through it.
he has seen.
I have gone through it.
What is there?
It's again, old wine, new water mine. Same thing has been repeated.
Madam,
177 because were acquired.
Where they paid in cash or by check?
that that receipt money receipt register, madam.
No, I'm not on that.
Traceable, madam. Yeah,
How do you pay the money? You pay it in cash or
payment is not mentioned in the register.
that
madam.
cannot be, it will be in check,
Receipt
right?
register.
At that point of time.
There is a receipt register, madam, I am told. But that is after sitting, madam, it is not, they could not trace out, they are paying for some more time, madam. That's a letter received on 3rd of June, madam. It is, they have.
Ms. Das, get me an information whether this money was disbursed in cash or by check
Mode of payment.
payment. If it is by cash, I am sure there is nothing. But if it is by check, you still have a mode, way to reconcile.
Lordship, but since, madam, that register is not traceable, madam. That's why.
Have you filed a FIR to that effect?
They are.
Ask a competent, we have been asking, we have been giving you much time. Ask either the deputy commissioner or the person conversant with this. Who is the person? Settlement officer. Under whose control is this records to him?
They have received letter from ADC. madam, that
ADC
they
is
are
not the
reporting
person.
branch.
ADC is not the person. Who is the person?
Trace out the mallet register. Maybe please to grant mallet to its stand so that mallet we can produce it, mallet.
Who is the land acquisition? He is the one, land acquisition officer is the competent authority or what?
Yes.
Who does it?
actually,
ADC mallet.
ADC.
it is entrusted with one of the ADCs.
Branch, he is the in charge of mallet that branch.
See, the person who was before us is no longer in this world.
6869
Yes.
mallet, 6869 land acquisition mallet was done at there, 6869.
And I find that
Mallet 2012-67 and case number 9 of 6869. But here it is mentioned, mallet.
Yes, you does in terms of the orders passed by this court on the earlier dates of hearing has submitted that the records as required in the matter has been received by her. However, she submits that it is not, she is not in a position to categorically state that from the records that the money was in fact released to the original petitioner. Full stop. She submits that the money payment, the receipt book wherein the money amount involved was so disbursed is still not traceable. Still has not been able to be traced out, and accordingly prays that she be given some further time to trace out. She accordingly prays that the authorities be given some further time to trace out the said records. Also, it is seen that the present proceedings are pending before this court from 2012.
Actually, a direction should be given to the ADC so that he can do it in conjunction with the Director of Revenue Records. I mean,
I'll do that.
Lordship, regarding Malab, my submission will be recorded like that, Malab, in the record, I have find that.
I said you cannot categorically say.
Malab, who
if you-
has received
No,
that.
no, that's what I'm saying. You cannot categorically say. You cannot categorically tell me that this is the thing. Kilhiju? Court since 2012, and it has been the stand of the government, respondent authorities all along, that the payments, that the compensation as involved in the matter was already released to the original petitioner. Also, it is submitted in the matter that it is submitted at the bar that the issue involved in the present proceeding is being monitored is being looked after by the additional deputy commissioner,
And the petition.
land acquisition branch. Full stop. Accordingly, this court directs the concerned authority presently, that is the ADC, land acquisition branch of the deputy commissioner's, district commissioner's office,
Right.
Kamrup, Metro, to place before this court all requisite particulars on the next date fixed. Full stop. It is directed that in the event the records indicating the payment made to the petitioner, original petitioner hearing, is not produced before this court on the next date fixed, the said authority shall personally appear before this court to explain as to why the said records are not in a position to be produced before this court. Full stop. Ms. Das has submitted that the records involved have been misplaced.
No,
If-
I'm not, it is my instruction, Malab, that. it is
That's what
not-
I'm saying.
Yes, not
Miss-
retrieved, Malab, could not be
Ms.
retrieved.
Das has said that Ms. Das has contended on instructions that the records
Repeated charge.
pertaining to the matter have not been retrieved.
Retrieved.
In other words, the said submission would mean that the records either have been lost or misplaced. The ADC come land acquisition officer, a land acquisition branch shall also apprise this court as to the steps taken by him when it was found that the said records were either misplaced and or lost. Also, it would also be brought on record where this court would also be apprised as to whether any proceeding was initiated against persons under whose custody the said records ought to have been kept. The above instructions shall be furnished to this court,
3 weeks time may be granted, so that. you can
furnished to
advise
this
that.
court by the said authority by personally appearing before this court at 10:30 AM on
Malab,
24/6/2024. You do whatever you want to do now.
Whether he will have to come and.
He will have to come personally.
And if he.
If he
finds
gets
out
the
that
records, you
government-
produce it. We have nothing to say.
Got
If
it.
he does not get the records, he'll be here personally.
All right,
You will have it by evening.
24. Malab,
After
Order.
the corrections,
order.
you will have it by evening. Order.
Got it.
Only depends how much rounds of correction. If it one round, it's done, fine. Otherwise, if it goes for 2-3 rounds, maybe evening.
Only my submission is that record.
That does not categorically indicate.
Malab, some lordship understand. Malab.
all right.
Yes, Mr. Islam, who is objecting you? Erosion and flood. Flood permissible, erosion not permissible. Then how can we help you?
My case is that due to.
You have filed a rejoinder here. Hmm? And the word used at page 45 is flood and inundation, right? This document that you have brought on record has finished your case. Have you understood how? Your case is, even if it is erosion, it is on account of flood, I should be paid. Right? That is your case. Now you come to page 41. Page annexus 6, page 6 of your rejoinder.
Police.
That is the policy. You are relying on this. You are relying on this. Come to page 45. You have got page 45? Read A. Storm.
Cyclone,
Hmm.
typhoon, temperatures, hurricane, and flood.
Flood and inundation. So you say, my case is covered. That is it. Now come down. Special exceptions. The company shall not be liable in respect of.
Damage or restriction.
Right? Come to the next page. F. Normal cracking, settling or bedding down of new structure, settlement or movement of made up ground, coastal or river erosion. Your house is damaged because the land below it was eroded. I was with you when I was reading the paper till I got this. Now I can't help it.
They said that river erosion. Insurance company's case is due to erosion, it is there.
It will not be.
My case is that due to get.
It cannot be, because what happened to your house was standing on this plot of land, like this, here. Now the river took away half of it. So your house became damaged. That is not attributable to inundation. That is attributable to river erosion. River erosion is not covered. And we'll have to go by the contract. We can't go beyond that.
Case, you're not correct, but because it's not the case, my case is that I have recently we have I have insurance with that earlier 2 years back.
I got it. If it was inundation damage caused, you would have got it. But now, because of this very document which you have brought, who asked you to bring this? We would have been in doubt otherwise. We would have come in your favor. I was totally in your favor. When you examine such cases, you always think about your own house also. Human tendency. But see, the petitioners, the respondents were saying this is not covered, this is not covered. I was trying to find out something. I was not being able to. Then when I went further, I found this policy. This is the one which will give me some clue. I came to F, finished.
Court earlier asked the body, that's why I have annexed. But my case is that you also can, the last page, you also page, and except 2.
60?
My reply,
How much? What?
and except 2 years, report of the circle officer also.
Come to the report also now.
Eroded by the reviving India.
Page 65, you come to the last paragraph.
So in the year by river Harangi in the year 2012 at the time of great flood.
No. Page 65 you are reading?
That's the report of the circle officer.
Page 64. No. What is the page? No. Give me an internal page. 28.
It is 29.
29. You come to the last paragraph. You read the vernacular one. Abedankarir.
Hondia Moser Ontogota Etnong Bodani Gaur 13 নং আবণ্টিত তৌজি মাটির
Hmm.
68 নং দাগত 1 বিঘা 4 কঠা 19 লেচা মাটিত অৱস্থিত পকী ঘৰ এটি যোৱা 2012 ইংৰাজী চনৰ প্ৰবল বানপানীৰ সময়ত হেলেংগি নদীয়ে উঠুৱাই নিয়াত ভাঙি নদীত জাহ যায়।
Nodir,
প্ৰবল বানপানীৰ সময়ত হেলেংগি নদীয়ে উঠুৱাই নিয়াত
Utuainia.
ভাঙি নদীত
That means it eroded.
Yeah.
Finished.
It is due to that erosion is due to get flood. Due to that erosion,
Two different things. Flood means it will come, it will submerge your house. And then it will go off. Whatever damage happens, you will be paid. This is erosion. That means it takes away, and their plea is that you had not disclosed that your house is near the, but you say that before I was given that insurance policy, a surveyor had come and said, they come up and reply that for 361 rupees insurance, we will pay 2,500 rupees to the, naturally.
they said, but in the duty, they cannot win that because their duty. Because every time you also know that at the
Huh?
time of opening the insurance policy, they already welcome. you.
Can't help it, but
at the time,
these-
they
these-
they every time they happen.
Huh?
Not the policy. At the time opening the policy, any policy, they have every time welcome it is okay, okay. At the time of that payment, they always. even that-
That is their thing. But see, they are supported by their own policy, which you rely in your affidavit.
You rely on that policy. okay.
And in paragraph 4 of your reply, also you say eroded. Right? Page 2. Hmm. Nothing.
Due to flood, eroded is correct, but due to get flood suddenly,
Both are different, Mr. As far as, because otherwise they would not have specifically excluded erosion. Better case next time. Heard Mr. S. Islam Learned Council for the petitioner. Also, Islam for the petitioner. None appears for any of the respondents. Also, the petitioner, by way of instituting the present proceedings, has presented a challenge to an order dated 12/12/2013, passed by the Insurance Ombudsman, rejecting the complaint as filed in the matter by the petitioner before the authority. Also, the petitioner had taken a householder's insurance policy from the National Insurance Company, Borpeta Road branch, insuring his house and entire household items. And the said policy was valid from 10/5/2011 to 9/5/2012.
12, 9, 10, 5, 2012 to
Where is that? Where is that?
page 14,
Page
14,
40.
14.
14.
Policy-
Was valid from
Policy period 10/5/2012 to midnight of 9/5.
was valid from 10/5/2012 to midnight of 9/5/2013. However, on 16/6/2012, on account of erosion caused by Velengi River, the house of the petitioner was damaged and was rendered unfit for human habitation. Right?
Okay.
Full stop. The petitioner accordingly under the said insurance policy as taken by him, approached the insurance company claiming compensation for the loss as occasioning to the insured building of his insured dwelling house of his. So the total loss as estimated by the petitioner was to the tune of rupees 5,40,600. Also, on receipt of the said claim, the insurance company deputed a surveyor to assess the loss so caused to the dwelling unit, to the insured dwelling unit of the petitioner. So, the said surveyor, on making the necessary assessment, submitted a report holding that the loss as suffered by the petitioner is not on account of a risk covered under the householder's policy. Accordingly, the insurance company repudiated the claim of the petitioner hearing. Being aggrieved, the petitioner approached the Insurance Ombudsman Guwahati Center by way of instituting complaint number GUW-G-048-1314-0219. The Insurance Ombudsman, upon hearing the learned counsel for the parties and counsel for the parties on perusal of the materials brought on record before him, while order dated 12/12/2013, upheld the decision of the insurance company in repudiating the claim of the complaint hearing. Full stop. The insurance ombudsman, by holding that such repudiation was just and reasonable, proceeded to dismiss the complaint as filed by the petitioner in the matter. The insurance ombudsman, for the purpose of arriving at his conclusion that the claim of the petition, that the repudiation of the claim of the petition by the insurance company was just and proper, had relied on the risk covered by the said insurance policy and erosion by river not being one of the risks so covered, had arrived at this said conclusion. Full stop. None had appeared in litigation of word. Full stop. Mr. Islam, learned counsel for the petitioner has reiterated the facts and circumstances as noticed herein above, and accordingly his submissions are not reiterated herein. First, I have considered the submissions advanced by the learned counsel for the petitioner and perused the materials available on record. It is not in dispute that the dwelling unit of the petitioner as insured with the National Insurance Company as it is not in dispute that as on 16/6/2012, the dwelling unit of the petitioner hearing was under coverage of a household insurance policy taken by the petitioner hearing from the National Insurance Company. It is further not disputed by the petitioner that the damage as caused to his house was on account of the erosion caused in the matter by the waters of the river Velengi, Velengi. Mr. Islam has contended that the household insurance policy, having covered the risk, having covered the damage on account of risk occasioning due to floods, the erosion being one of the consequences of the floods occasioned, comma, the risk, the claim of the petitioner could not have been repudiated by the insurance company and his claim ought to have been honored. Also, the said submission of the learned counsel for the petitioner is so based on section 1 of the householders insurance policy of the National Insurance Company, wherein under clause A thereof, flood and inundation is one of the circumstances wherein the company indemnifies the insurer for the loss or damage to the building and its contents. Also, however, the said policy under the heading special exceptions in clause F thereof provides that such indemnification of the loss and damage to the dwelling unit shall not be extended in respect of coastal or river erosion. Also, the provisions of the special exceptions being relevant, the relevant provisions of the said apostrophe D, special exceptions, comma, being relevant is extracted here in below. Apni page 45 what? Special exceptions. The company shall not be liable in respect thereof. Ekhini likhi A ... D F to put koi dibo. A to A. Huh? F to moi A to A likhi thoisu. কিন্তু এখানে লিখিব কিন্তু স্পেশাল এক্সেপশনস আৰু এইটো এই দুটা লাইন লিখি ... দি কেনে F2. Also, the set provisions of clause F under the heading special exceptions having excluded the liability of the company for the damage occasioning to the insured dwelling unit on occasion of river erosion damage to the dwelling unit on account of erosion by a river, comma, this court does not find any error in the action of the part of the insurance company in repudiating the claim of the petitioner herein. It is to be noted that the documents as produced by the petitioner in support of his claim, including a report by the circle officer, also clearly indicates that the damage occasioning to the house of the petitioner was on account of the erosion caused by river Velengi in the year 2012. Full stop. Also, in view of the above position, the repudiation of the claim by the National Insurance Company, claim of the petitioner by the National Insurance Company does not call for any interference by this court. Also, the repudiation of the claim by the National Insurance Company having been held to be just and proper, the decision of the insurance ombudsman under challenge in the present proceedings also does not call for any interference. Also, in view of the above, the writ petition is held to be devoid of any merit and accordingly the same stands dismissed. However, there would be no order as to this. Can't help it. You dug your grave yourself. Anyway, this is a learning experience for you also, me also. Beleg Nair. Thank you. Tom, you can hear me?
Yes, my lord, loud and clear, my lord.
Okay. Yes.
First, I will address your lordship
Hmm.
on the point of maintainability.
On the maintain.
Point of maintainability, because that was the point which was raised before division bench. And division bench has specifically a direction was passed by division bench that particular maintainability also is being kept open, you can decide. So your lordship first.
Let's go to
want
the division
decide
bench
the
order
point of
first.
maintainability.
Let's
So
go
let's
to-
go to the first point, that if your lordship decides it is not maintainable, then it's gone. Your lordship has no need of troubling to other aspect of the matter. So first, my lord will kindly see paragraph 2 of the petition, my paragraph 2. That is page 8. Internal page.
No, let's just have that observation of the,
Yes, I'll just draw your lordship attention. Division bench order. No, I'm going to follow this one.
so small.
Kindly see the last paragraph, last page. Page 8, the question of whether a power of attorney holder can maintain a writ petition on behalf of the actual landowners may also be an issue. That the learned single judge may decide to deal while re-hearing the matter. ये तो यहाँ में नहीं होगा, ये पुराना विषय नहीं है।
This is an objection taken by the Union of India. Let them raise that.
That's lordship will kindly note down. That was not an objection when the affidavit was filed. Anyway, subsequently.
That
this
I'll
was
take it
taken.
down when I come
This
to.
was- This was subsequently it was taken. This time.
I'll record it. Let's hear Mr. Dole on that,
No,
what he has to say.
no, let me first.
No, let him raise that objection.
Let him raise. No, no, for our case. Yes, let him raise.
You then
Yes.
come back. Yes, Mr. Dole.
Let him submit the, because.
Why should, it's an objection you have raised. So you have to satisfy me first, then we will go. You satisfy me that this is an issue. Why?
No, but
A power
actually
of
what-
attorney
regarding
holder.
the power of attorney, actually what has happened, my lord, and some people are taking the, I mean, so many cases I have been doing.
You
and
give me
they have
the,
been-
you
they-
make the legal submissions on that
Yes,
effect
my
that
lord, they
this
have-
is the
yes, my
ground
lord,
why
they-
it cannot.
Yes, my lord. they
Then we
have
will
taken the
we'll
power of
respond.
attorney. And my lord, beneficiaries are, the land actually, those who are belong, they are not, my lord, petitioners over here. They are, because what happened, power of attorney holder is the petition.
Show me some decision of the Supreme Court.
We don't want to comfort on that, my lord.
But no, you have taken a plea. I'll have to answer to that.
Yes, yes.
You tell me you are giving it up.
My lord, this is a fact.
You
actually.
tell me you are giving it up. I'll close the matter because I'll have to record.
Because I don't want to press much on this, because what happened in a power of attorney act, attorney holder is having the right, my lord. Well, I don't want to much press on it. Because this is a fact, my lord, what is happening across the owners, my lord. Even some relief is given to them, the actual beneficiaries, whether they will get the money, how much they will get, that is the question. So that is why this point
No,
I don't
tell
want to
me,
give much.
you address
I
me
don't
on
want
the,
to give
Mr.
much
Dole,
press on this.
Mr. Dole, you address me on an issue
Yes.
as to whether in absence of the petitioner, the attorney holder by him in his own name can institute a proceeding.
Yes, madam. They can
He can
go for the
institute-
proceeding, yes.
Then why was this point raised?
But that point was, that particular time it was raised, that time when, that
Then
I was
there is
not.
nothing,
No, my lord, that time I was not in the case. Subsequently, I came into the case, my lord.
be that as it may. Your authorities have raised it. Now, if your authority says that you are giving up that, make a categorical statement, I'll record it. That will close that issue. Because I'll have to answer that issue.
Yes, yes, my lord, that what happened, my lord, in Arunachal, what is the,
No, no, Mr. Dole, first thing, forget Arunachal, what is happening. You give me the legal perception.
yes, my lord.
That
yeah,
this is
power of attorney
maintainable
holder is having
or
the
not?
right, my lord.
Then you are giving up on that.
Yes, yes.
I'll just record that.
He's given up.
He's given up. Then I can't, why should I go in now?
Yes, yes,
Once Mr. Dole has given up,
yes.
why should you trouble yourself?
He just- No, that's right. I prepared everything on this spot.
Just
So
show me,
subsequently I will come.
for my understanding.
I'll give a note, a particular judgment. Yes, no, copy. No, no, this.
No, no,
Yes.
just show me your note, what it
Yes,
is.
note means the judgment.
That's
My lord, this.
Mr. Dole,
But this is not the.
you are
sub-
giving up a very vital point. Be very careful. You are giving up a vital point. My research also shows something.
These are the judgment on the power of attorney.
What is
I'll
it?
tell you, Your Lordship. It's very important, interesting, very point. I'm thankful for all my learned friend who has got a judgment. First, the Supreme Court made it very clear what is the effect of a power of attorney. This is Your Lordship. That day also Your Lordship has seen that there is an act, which is a Power of Attorney Act. Now, how it is being dealt? Now, there is a provision under the contract of agent and principal. Now, the Supreme Court said the role of power of attorney holder is like he is an agent. And the principal, the landowners are the principal. So he acts, the agent is nothing. He acts on behalf of the principal as if the principal is in the court. That's what the Supreme Court said.
Show me.
And,
Show me that
and
judgment.
my lord, he doesn't, but that point has been given up.
Just show me
For
that
your
judgment.
lordship understanding.
For my
See, my
understanding.
lord, No, your lordship is going, see how, now, next is important. My learned friend has given up this. How this writ petition was structured for your lordship understanding. Paragraph 2, it is written how the power of attorney was given. It is backed by an instrument from page 27 to 27 onwards. The how the power of with an instrument registered. It has to be registered. It is registered. Number 2, how it has been dealt by the apex court, that your lordship wanted to know.
Maybe the respondents have not got the point.
I'm sorry.
Respondents may have not got the point. The issue that was raised by me on the last occasion following the DB's
Yes.
observation was, in absence of the names, if I have understood it
Yes.
properly, in absence of the names of the principal as the petitioners, whether the agent can be the petitioner and
Yes, it can. I'll give an answer to it.
that.
That
what is-
also point I have looked into it. I have looked into that point and how it is described. See, initially, I'll tell you without going into, I'll show the
Just tell me, because now
there
it's for my
was a
understanding.
judgment by 3 judges of the Allahabad High Court, which was the present in the Chief Justice of India. There were 2 judges where Allahabad High Court said, a power of attorney only who can come to the court. Only power of attorney can come to the court either by a writ of habeas corpus or by writ of quo warranto. Rest 226, power of attorney not applicable. Either writ of search or writ of mandamus.
He can be a signatory to the affidavit.
Now, my lord, it went with the full bench.
Hmm.
Were headed by the present Chief Justice of India. Now he said the division bench where Allahabad High Court decides on these 2 points, 3 judgments were cited. He was we respectively we disagree with that. We disagree with the judgment which was passed. 226 also, power of attorney holder can come into it.
On his own institute a proceeding without
No.
the principal being brought
Yeah,
in.
I'm telling your lordship. Now your lordship puts a query. What happens when the wakalatnamas are not being signed? This is the issue, wakalatnama. Greatest respect, I'll show one judgment. That's how intention of the
I'm not even
legislature-
on that, Mr.
No,
Mr.
once the
I'm
power-
not even on that.
No, once the power of attorney has been given by the principal to the agent, he acts on behalf of the principal. Now, the wakalatnama also, to my understanding, how many about a number of cases, not the wakalatnama has to be signed by each of the petitioner who represents. He represents on behalf of the principal.
I
he
got
can
it.
sign the
I'm not
wakalatnama.
even on that. I
Yes.
am on the description of the party.
Yes, description of party is there.
No, it's not there.
No,
It's
see it.
it's the power of attorney holder who is the petitioner.
No. The power of attorney holder will be the petitioner. Power of attorney holder will represent as if like a
See,
petitioner.
being a petitioner and representing a petitioner, is it the same
No,
thing?
no, kindly see that. Then your lordship, let's say, has to look into the judgment. Then your lordship has to look into the judgment.
Just give me, just because,
But the point has been now is
given
abandoned.
up, but division bench has directed me to
Yes,
look into
no,
that. So
independently you can decide.
I'll
but
have
your
to
lordship
decide.
can Note down that that's been given up.
I'll make
Yes,
it.
yes.
So Dole has been
See
fair.
the judgment, first judgment of 2016 3 SCC 296, where the notice that I have given the judgment. See
Para
that?
36 and 30. Kindly
Yes.
read slowly.
I have given the list of books. this one.
That you give it just before
Yes,
that, it will not come.
difficult, yes, difficult.
It's okay, no
I
need, you
find
read it
very
slowly.
Difficult, my lord.
Read it slowly.
There, I found there.
That SSC
I
also
find it
today morning, I
difficult.
found that it is gone.
I find it difficult, my lord, honestly speaking. This type of
Please, 36 and 30.
these books are, that's why we carry at our time, I remember 2-3 books. So that, because 1 second you make a particular, that's a gap, everything goes.
Okay, fine. You just
So
read.
see
No
para
problem.
36, I'll read para 36. I'll just read slowly. The law relating to power of attorney, it's a judgment in 2016. The law relating to power of attorney is governed by the provisions of the Power of Attorney Act 1982. It is well settled therein that an agent acting under a power of attorney always acts as a general rule, in the name of the principal. Full stop. Any document executed or thing done by an agent on the strength of the power of attorney is an effective as if executed or done in the name of the principal, that is by the principal himself. That's full stop. An agent, therefore, always acts on behalf of the principal and exercises only those powers, which are given to him in the power of attorney by the principal. Full stop. Any act or thing done by the agent on the strength of the power of attorney is, therefore, never construed or / and treated to have been done by the agent in his personal capacity so as to create any right in his favor, but is always construed as having done by the principal himself. Full stop. An agent, therefore, never gets any personal benefit of any nature. Applying the aforesaid principle, this court in Suraj Lamp and Industry, State of Haryana, held in para 20, 21. These are all judgments which has been referred by this court in 2016. Now, paragraph 37. When we apply this well-settled principle of law, now to the facts of the case in hand, we are of the considered view that when Dhanapal, who was acting as an agent of A. Radhakrishnan on the strength of power of attorney, executed the tenancy agreement with respondent number 1 in relation to the suit premises, then he did such execution for and behalf of his principal, A. Radhakrishnan, which resulted in creating a relationship of landlord and tenant between A. Radhakrishnan and respondent number 1 in relation to suit premises. In this execution, Dhanapal, being an agent, did not get any right, title, and interest of any nature either in the suit premises or in the tenancy in himself. The effect of the execution of tenancy agreement by an agent was as if A. Radhakrishnan himself had executed with respondent number 1. So I am just correlating with the facts of some tenancy agreement, power of attorney was given. So the person doesn't come. So he acts himself as like a principal has come to the court.
What are the names of the parties there?
My lord, it's Kasturi, Radhakrishnan and others.
Why was the matter taken up to the Supreme Court?
This is Supreme Court.
No, why was it taken? How was it
Yes.
taken to the Supreme Court?
This was, my lord, necessary party, co-owner, joinder of all co-owner of premises not necessary.
Just read the first paragraph.
Uh,
So that we get
first
the
paragraph.
facts now.
Yes. The appeal is filed by the plaintiffs against the final judgment order passed by the High Court of Madras in so and so, allowed the revision petition filed by respondent number 1 herein and set aside the judgment of the principal subordinate judge so and so. In order to appreciate the issue involved in this appeal, it is necessary to set out in brief the relevant facts in relation to eviction case out of which this appeal arises, and also state the facts of 3 cases filed by the party in respect of the suit premises because they were referred to in the proceeding out of which this appeal arises. Paragraph 3. The appellant plaintiffs are the wife and son of one A. Radhakrishnan. The suit premises bearing door number S3 so and so, this is a suit number as was allotted to A. Radhakrishnan by Tamil Nadu Housing Board. In fact, entire area was acquired by the Housing Board and one house site therein was allotted to A. Radhakrishnan. Subsequently, A. Radhakrishnan made construction on the site allotted to him. On 22/2/1987, A. Radhakrishnan executed a general power of attorney in favor of one V. Dhanpal and nominated him to manage the suit premises on his behalf. One K. Kalidas was in occupation of the suit premises tenant. On 4/2/1998, he vacated and surrendered the position of suit premises to Dhanpal. Thereafter, respondent number 1 took the suit premises on lease rent from Dhanpal under a written lease dated 12/2/1989 for a period of 11 months on a monthly rent of ₹850 and paid ₹4,000 as advance. Respondent 1 then obtained possession of the suit premises and started residing therein with his family. The appellants, however, came to know that A. Radhakrishnan, without their knowledge, entered into a sale agreement dated 30/7/1987 to sell the suit premises to one A.S. so and so. The appellant therefore instituted a suit being OS number so and so in the court of District Judge Erode and sought a declaration that the sale agreement dated was so and so 1987 neither valid nor binding on them, and also sought a permanent injunction against A. Radhakrishnan, restraining him from executing the sale deed in favor of A.S. Pongiana and delivering possession of the suit property to him. In this suit, respondent 1 was impleaded as one of the defendants. Respondent number 1 filed a written statement in the aforesaid suit reiterating that therein that he was included in the suit premises tenant under a lease deed dated 12/2/1989 for a period of 11 months at a monthly rent of $850, and on the expiry of the contractual period of lease, he continued to remain in the suit premises as a tenant. Respondent 1 also in the meantime filed a suit being so and so against A. Radhakrishnan and the appellants herein seeking permanent injunction restraining the appellant from dispossessing them from the suit premises. According to respondent 1, he was a tenant and was put in possession of the suit premises by Dhanpal.
Okay.
The power of attorney holder. Now.
Okay.
Now,
So this
my lord,
question, we'll give it a closure.
now, my lord, one more judgment, I think, lordship, that will really help what I felt.
Please.
And people filing for
Now, my lord, will kindly see, your lordship query was that what will happen to others? Because in this says one Kora has filed. Kora has filed. That's what I think, if I am not mistaken. What will happen? So for others is concerned.
That your prayer is to.
Now, yes,
That,
right.
that I have got it.
I
That
got
I
it.
have got
Now,
it. There is no
see the
dispute.
Allahabad High Court judgment. That is very important from para 20. See para 20. This is full bench. The decision of division bench. I told there are 3 division bench were cited to 3 judgment. The decision of division bench in Prabhunath Prasad Gupta was followed in another decision of division bench in this court in Rustam so and so. In that case, at the judgment of division bench indicates what was held was that the power of attorney which had been executed was a special power of attorney to execute a formal agreement for sale in favor of 3 vendees, inclusive of various other acts to conduct the proceeding for conversion of the property into freehold before the appropriate authority. Division bench held power of attorney was made to protect the interest of the alleged purchaser of property. And since the power of attorney was a special power of attorney to espouse the case of the vendees, petition was virtually a proxy petition. This is important, my lord. Proxy petition by the holder of a power of attorney. This observation of the division bench indicate that a power of attorney was for a specific purpose. The judgment of the division bench hence cannot be considered as laying down any principle to the contrary. However, division bench also held as follow. Now is important. In any event, a further question can arise before this court whether a writ of certiorari or mandamus can be issued in favor of the power of attorney holder, on which there is a direct judgment of this court being Dr. Prabhunath Prasad Gupta versus so and so, which was held that a writ petition by the power of attorney holder of the petitioner seeking relief in the nature of writ of certiorari for every person is not maintainable. Now, this particular judgment is referred by full bench saying that it was. Now, see, now
This is my query. This was my query.
that's why. 21. For the reason which we have indicated, we are unable to subscribe to the above broad proposition which has been laid down by division bench following the earlier decision that a writ cannot be filed through the holder of a power of attorney for seeking relief under Article 226 of the Constitution. The order of referable also adverse to another judgment of this bench, division bench in so and so. The division bench held a writ petition by a power of attorney holder for the purpose of seeking individual relief of an aggrieved person, either in the form of writ of certiorari or a mandamus or prohibition, cannot be allowed under any circumstances. Para 23, for the reason which we have indicated earlier, we hold that we cannot subscribe to the broad principle of law which has been initiated in the following decision. That is 1, 2, 3. Now see 24. When a writ petition under Article 226 Constitution is instituted through a power of attorney holder, the holder of power of attorney does not espouse a right or claim personal to him, but acts as an agent of the donor of the instrument. The petition which is instituted is always instituted in the name of the principal who is the donor of the power of attorney and through whom the donee acts as an agent.
Thank you.
That's what. I think the point of maintainability has been answered.
We will not pass a separate order. We will go together
Yes, yes,
with the main order.
This is the first point. The second point, I think your lordship, that day it was heard. I think your lordship knows the facts of the case because there was some correspondence. I'll take your lordship.
Now,
From-
the second question that will arise before we
Yes.
go into the merit is the plea of Mr. Dole or the respondents that this land was acquired by the government without a necessity being expressed by the competent authority in the matter for that.
Appropriate authority.
Appropriate authority for that. And Mr. Dole had referred, we'll hear in details from that. But basically the contention is, if I've understood it correctly, that the state has made this acquisition. Some major had made some requisition, but it was not a requisition which was made by the competent authority, which rather boiled down to be the defense estate officer, Jorhat. This is basically the contention. Now you can take me to that.
I'll just give an answer to that one. See, kindly see my read petition from page 67.
Page?
Whether, because the first will be whether it was with the knowledge of defense estate officer or not. Page 67.
So the question would be whether the acquisition proceedings were so initiated on a
Whether-
requisition made by the competent authority of the
Whether
unit.
it was within the knowledge of defense estate officer or
The
not.
knowledge will be, that question would be that whether
Yes, authority, appropriate authority.
appropriate authority.
Authority. My lord, they kindly see the date. This is very important. On page 67. 7/2/2017, the date.
67. Okay.
Lordship got it?
Hmm.
67.
Hmm.
This is a defense estate officer, kindly see down below.
Hmm.
And this is the appropriate authority.
That,
This
that,
is my
Mr.
submission. Would have-
No, Mr. Dole has also
He's the
said that that is he's the appropriate authority.
Yes, he is the appropriate.
Before I read this letter, my lord, I'll humbly submit before your lordship that if there was no sanction, this was a query. In
The
principle,
sanction
approval
was that
and-
there was no approval from the competent authority for this, or we'll put it in a simple way, from my
number one,
understanding, requisition for this acquisition.
Number one, it's in principle, there was an approval. I'll show it.
Hmm.
It is by their letter. Whether a sanction is required or not, that is another question to be, I'm putting it. Whether a sanction is required or in principle is done, so you can proceed. This is another way of putting it. Now, if you see page 67, this a defense estate officer is addressing to some JKRF, what this their APO, forwarding of joint survey maps. Lordship got it? It is intimated that joint survey of the following pockets of land have already been completed during the month of December 16 and first week of January 17 by so and so staff, ADC so and so, and representative of local military authority. Joint survey map of the following location, 10 copy of each location, duly signed by this office are forward herein. Number two, you are requested, now all these copies, total areas in acres, number of maps, all have been attached. Number two, you are requested to get the signature of the revenue authority and your represented and forwarded 2 copies of joint survey map of each location to this office and 2 copies of ADC and remaining copies to be maintained by you for enclosing the same in the BPs for acquisition of private land of so and so. Now, this is at page 68. Kindly turn to page 68.
Yes.
See kindly page 68. Copy to the additional deputy commissioner so and so. See on the right hand side. For information, please, you are requested to forward the following land acquisition document as per LR Act 2013. Willingness certificates, land ownership certificate, D cost of land, E site map, F certificate, G NOC from concerned forest department, land proposed for acquisition by the army does not fall under definition of forest land. H certificate regarding non-applicable rehabilitation resettlement scheme in the instant applicant cases provide in so and so. Now kindly see 16. Same, my letter has twice, it has been annexed here. So now, my lord, after this, all the clearance was given from the state side, which your lordship will kindly see from 17.
Now, one thing, Mr.
Yes.
Das, what is the requirement for this documents under the Act?
Which documents? My
The documents at page 68.
page
68.
68. No, all clearance, if you acquire, maybe there is no forest clearance, is a forest land. Then willingness.
No, I'm not on that. I'm not on that. What would be the authority be required to do? The requisitioning authority, once these documents are placed before it.
Yes.
What is the act he has to do now?
Act.
Say these documents, the state forwards it to the competent authority.
Yes.
DU. Let's say it is forwarded.
Yes.
Now, what is the DU to do? He is to just keep
They
the
will-
matter in his records, or he has
They
to
will
act?
forward it. They will forward this DO will forward it to the Raksha Mantri or whoever the authority is concerned.
Then what is prepared to be?
Then they will look into it.
And
They will
then,
look into it.
then,
Then they will again forward. They will say you act on the basis of that.
so you mean to say that once these documents are produced by the state
Yes.
to the DU,
Yes.
he will forward it to his competent authority. to take a decision on that and then revert back to the state.
Now,
Thereafter-
now, suppose for a moment.
Thereafter, the state will proceed with the
Now,
act.
suppose, I understood. But the why your lordship is putting.
When
it
I'm
very-
asking a clarification,
I-
Mr. Das
I
is
have
much,
also- Well, I know, but
I know that.
I had the privilege of appearing for lordship as a lawyer also. So that's why I know, my lord.
No, no,
No,
this
that's
is a
what
doubt.
I'm saying. Yeah, very
But
important
that's the,
question.
that's
No,
the
just
basis.
apart, my lord, there's an important question has been put forward. What happens? These all NOC sent,
I'll
certificates
clear
sent.
my mind. I'll clear my
I
mind.
know, it is
The-
being sent, what they doing?
Hmm.
What is their role? That means meaning thereby, if it has been sent to defense asset officer, now defense asset officer has sent to the authority concerned. They are sitting quiet. They are not doing anything. Then what means? Whether the notification by the state could have been issued, waiting for that. That's what your lordship is in mind.
No, I'm not on that. Whether the act requires after because last time an impression was given to me
Yes,
that joint inspection has been made, that is the end of the matter. That is why I have asked them to get those office files.
yes.
4 months delay was there. After this 7/2/2017, there was around 4 months delay in issuing the notifications by the state. So the ball was set rolling with that
Yes.
notification. Now they are forwarding this they are asking that kindly forward back these documents to us. Now, whether the defense estate officer has to come back, say that, okay, this is fine, or he has to say nothing. You proceed. We have given you in principle proceed, you proceed. What is the situation as per the act?
As per the act, that's really, I have not gone through that particular one. As per the act, what happens? As
Because
per the act.
you make a joint inspection, fine. You get the reports, we accept. Now, I, as the requisitionist, I also must know what would be my commitment required for that.
If you go strictly by act, under the land acquisition 2013, unlike 40, which they have done, you can't say now that wrongly it has been done, we want to withdraw it, you can't say. That's why I'm making it very clear, my lord. And the intention of legislature was that once you particular for the purpose for which
Oh.
you want.
I will give you a further clue.
Yes.
If you come to D in page 68, clause
Page
D,
68, yes,
cost of the land,
yes,
along with the basis as per government approved rate, government notified rate.
right.
This would come in only after the award is given.
No, no, no.
Estimate, sorry,
estimate.
estimate.
So,
So estimate can occasion only after the notice is
no,
issued.
no, I'm telling you, lordship, this estimate, not in the case, but see, it's a unique 41, which a parameter to 17(1).
We'll
No,
go
no,
to
that's
that.
what- No, it has a connection here,
Hmm.
because your lordship is putting this in award. Or you said estimate or estimate.
I'm
This
not on the specific case of this case. Here it's a case of 40,
Yes,
17.
yes,
But what I'm asking you is, if an estimate is also to be prepared in the matter, be that as it may,
Hmm.
whether it's 40 or for my understanding, for that the proceeding, the notifications, does that have to be issued thereafter the estimate is sent to the government? Or an estimate is sent even before section 4 notification is issued?
no, it has to be before, all the estimate has to be made before it.
Before the
40, yes. Before 40 notification, estimate has to be made.
estimate, okay.
Estimate has to be made. Because why? It is unlike, my lord, it is not 40, unlike other provision. 9 and 11. My lord, if it is an acquisition under 4, I am telling your lordship 4. What happens, my lord? Let us take for an example that under the new act, it is now 9, I think. 9, 11 is 23 is the award.
Hmm.
No, what?
Let us go by 4 and 6.
Yes.
Old act. That is, we are comfortable with that.
So, my lord, what happens? Your lordship will kindly note down, once the in principle approval was granted in 2011, the process started. It rolls over. 2011, In principle, approval is granted, it roll over.
But you say before a notification under section 40 can be issued, the authorities have to prepare a estimate.
Otherwise, man, how? It
Now,
has to be prepared.
what mistake they have done in requiring you to place that estimate before them? How could you, the state act before that estimate was approved
Good.
by the authorities?
No, that's my lord, your lordship, I know, that's what your lordship was last time also.
This is my doubt.
Forward.
Mm.
My lord.
So it boils down to that.
Yes, my lord, kindly see, my lord. That means, my lord, the defense estate officer, now what is what they want? Their whole stand is that we don't require this land.
We have not reached
No,
that situation.
that's the whole
No,
stand.
we have not reached that situation.
No.
We are still in 7/2/2017.
Right,
We have not reached the state of the notification.
right,
Now he has sent the joint inspection report
right,
signed.
yes,
And then he asks the additional deputy commissioner, kindly give me the willingness certificate, land ownership certificate, NOC, cost of land along with basis as per government approved rate,
yes,
government notified rate, site map sketch of the proposed land, certified, NOC, certificate regarding non-applicability of rehabilitation and reception as provided so and so. Now my query
My
is,
telling your lordship, this has been done in pursuance to what your lordship is reading. In pursuance to that, which they have asked, the defense asset officer wanted. So on the pursuance to that, my lord, from page up to page 87. Up to page 87, the exercise which they have carried on. See 87, my lord, page 87. Sure. Now kindly see 87.
okay,
Kindly see 87.
okay.
All the annexures are addressed to the defense asset officer, including the cost also. Cost, map, everything. And that cost is page 89, your lordship will kindly see.
So 87 is 17/3/2017.
Yes,
And deputy commissioner does it.
yes. To the DO, defense asset officer. Because that's what he requests. Lordship has seen that. Copy, he requests all this. So it has been sent by the government.
Okay.
So all the exercise has been done.
So now we have the
Now, my lord,
rates, everything is ready.
everything is there.
Now
Then-
tell me,
Then the notification has been.
now
sent.
tell me.
Yes.
Is this an empty formula for formality, or there is some sense of application of mind required after this was provided by the authorities?
Now, my lord, the question is there. Once number one is principal approval is given.
We got
Father-
it with the
Father,
principle, in
what
principle
is it,
approval, we
my-
have it. We will come
That's
to that.
why
We'll come to that.
Once it is done, it has to be presumed that this land is for their
Fine,
requirement.
let us say,
Presumption has to be
Mr.
drawn.
Mr. Das, let us presume that
Yes.
this land we want,
Yes,
but we will also have to follow the step-by-step processes. Because tomorrow you come up and say that we will want 500 crores for this land. They will not be in a position to pay. So is it required that once these documents are forwarded to the estate defense officer, we'll use the word estate defense estate officer, he is the competent authority, that he has to apply his mind
Yes.
and say, okay, go ahead. Or empty formality. Why did you send it to him? Why was the state sending these details to him?
That the
If it
state-
was not a requisite because of the in-principle proposal, now you say,
No, you see,
now you say.
no.
One of your
One second,
arguments
I'll
was-
just reply. In principle, approval is given first, that you can go ahead. Then all these formalities has to be taken into consideration. Otherwise, they will not be able to do it.
That's it, what I'm
That's they
saying.
have to do it.
Now that you have done that exercise,
Yes,
you have made the estimate, you have placed it before him.
you cannot turn back and say.
We are
now-
not on that.
Yes,
Where is the approval of the authority
no,
that, okay, fine, this is good with us?
no, you don't.
You go ahead now.
My
Next
lord,
step.
We'll not use the word approval.
We will say application.
Sanction.
we'll
section-
say
See,
seen.
no, in principle, when you have.
If you
done
have
it,
a in principle
In
approval
principle,
already,
you have
why this
accepted.
exercise
No,
is
my
being
lord,
carried out?
My lord, kindly see, why they wanted all this? Then defense estate officer?
That's what
Forget
I'm
about
asking
the
you.
major part. No, that's why I'm giving.
Hmm.
I don't know, their stand is different now. That's why your.
We will
lordship
not
is-
make them take any different step.
No, no,
We
their
will
stand-
require,
Their stand is different.
Mr.
you-
Das, as far as this court is concerned, this court is still on 17/3/2007.
No, my lord, has to be correlated with this answer, which your lordship is putting to me. It's sorry to say, my lord, it has to be correlated. What stand they have taken now? Now today they have made a U-turn. Now they are now saying they're nothing doing. nothing
I'll
doing.
clarify that.
Yes,
They say now that we have taken the approval from our competent authority to rescind what we have already said. So to that extent, it tantamounts to a plea you can take that there was already an approval for this. But I am on a slightly different topic. Now that they have forwarded this to the district offense officer, is there a requirement that he has to apply his mind? You have no headache. The state has no headache. State has got no headache. It's only
my
when
lord.
the government says,
Yes, I know.
central government
That-
says, give us the land.
No, my role, our role to satisfy your lordship is over. Now it is between the state and between
We'll
them.
go to that. Mr. Das is
Yes.
there. Mr. Das is there. So I'm trying to understand. Just on a general proposition, once this is done, you have
No,
sent
I
it.
have understood. Your lordship want to know that what happens then, whether it go to the central government. and
Wherever.
what-
We
no,
will not
wherever-
go beyond the
wherever,
district.
What,
We will not go beyond
no.
the defense estate.
when it
officer.
goes to the authority to them,
Hmm.
what step they have to take? Whether they have to keep quiet or it is presumed that it has been.
Now
number one.
you see
Number two-
now you see the next step.
No,
taken.
number two, number
Hmm.
three, or some type of scene or sanction is required by them.
Whatever it is.
So if it is, no, let us put this way,
Hmm.
if it is not there.
What
then
would be the
happens
effect?
thereafter?
Now I am
Whether
telling you.
issuing of a notification.
Now I am telling you what.
Yes.
The DC, he forwarded these documents to the defense estate
Yes.
officer. Right? Now, if you come now to the actual rolling of the implication of the act, implementation of the act,
Hmm.
page 99.
99,
Hmm.
yes.
Now you see the words here.
Hmm.
Second paragraph.
Yes. Yes,
Come to the second paragraph.
I am marked likely. This is
So
what-
now when you with these words,
Yes,
when you consider these developments, how should this court approach the matter? And Mr. Das, this is a doubt which is there. I want it
Yes.
clarified.
yes. Now,
Otherwise, if this words likely to be needed is normally not found. I'm holding 4 and 5 now. I've seen around 50 LA. These 3 words are not there. It's a need.
no, that's, let us, because why I will say as an advocate, my lord, to assist your lordship.
Only
No,
to that. I'm not holding it
likely-
against you.
Likely to be needed.
Needed.
At the locality or locality more described in the schedule below for Indian Army, namely acquisition
What-
and so.
I'll ask Mr.
But-
Nabam. I'll
Yes.
ask Mr. Nabam as to why this
It-
was done.
That's a notification they have issued. They will know.
Because
that
you are a sufferer.
we
You are a
sufferer,
victim.
We are sufferer.
You are a victim.
We are.
Because that land, you are not being able to utilize once this notification was
Yes.
issued. And 80% was also not given to you.
No, this is, and number two, they have position also has been taken. over.
That's what I'm saying.
Position taken over.
Yes, Mr. Nabam. I'll just have a query from Mr. Nabam. Mr. Nabam,
My lord.
now you have heard the deliberations. You
My
have
lord.
heard the deliberations. This is just a tentative thought. Now, the defense estate officer, after the joint verification report, he signed it and forwarded it to the authorities of your government. Deputy
My
Commissioner.
lord.
In that letter, if you can come to page 16(7). That is the
Yes, my lord,
letter.
67, my lord.
You come to
Yes, my lord.
68. Come to 68.
My lord. Yes, my lord.
Copy 2. The Additional Deputy Commissioner Hailiang, Anjao District, Arunachal Pradesh. For information, please. You are requested to forward the following land acquisition documents as per LARR Act 2013. So he has asked for these documents.
My lord, sorry for the interruption, my lord. 68 page, my lord, we don't have any, my lord, copy to anybody, my lord. 68. So there is a defect in my petition. Anyway, my lord, I can share from my friend. It's all right, my lord.
Your friend has it.
Yes, my lord, copy to, yes, my lord. Additional Deputy Commissioner got it, my lord, yes.
So they have asked for these documents from A to H. Right?
Yes, my lord.
Now you come to page 87. Right?
Yes, my lord.
These
Yes,
documents submitted.
My lord.
Right? Now, what is your stand that once you have submitted these estimates, everything, is it a necessity or a requirement is there that this has to be some sort of a communication back reciprocating this action from the union government, or we'll say from the defense estate officer, before you proceed to take the next step?
My lord, my answer would be, my lord, after joint verification report, it was submitted to the defense state officer. Now, the defense state officer, he again, my lord, based on that report, again submit to the higher authority, my lord. My lord, for my lord approval, one can say. Now, my lord, while submitting, my lord, you lordship have seen, my lord, because land has to be, my lord, free from all encumbrances, my lord. That's why, my lord, we obtain NOC from the landowners, case mail, joint serve, everything.
Fine,
my
you
lord.
did all the exercises, but
Yes,
was
my
it
lord.
ripe for you to issue a notification under the LR Act before you got a confirmation from the authorities? Because why I am saying so, if you come to page 99,
My lord.
second paragraph, whereas it appears to the governor of Arunachal Pradesh that land is likely to be needed, because you also don't know, because that approval, that again fortifies the question whether that approval from the government or the reciprocation to page 89 was required.
My lord, I'll be very fair to this honorable court, my lord. Now, my lord, this entire land was acquired under section 41, my lord. Emergency clause was, my lord. Now, my lord, while doing that, my lord, there is a slight mistake or slight deviation from the procedure, my lord. Your
No,
lordship is correct.
that's why I'm saying
But-
that slight deviation would now mean
Now,
whether we can saddle the government of India with that or you will have to pay.
now, my lord, entire my lord, acquisition process was completed. Even final notification, acquisition, my lord, assessment, it was sent to the central government for approval, my lord, through DO, my lord. My lord, now you will say, my lord, is there any approval, my lord? Approval
And,
means, my lord,
sorry,
sanction of the, my lord, compensation amount.
Mr. Navam, sorry. Correct me if I am wrong. This copy at page 99 was not forwarded to the DEO.
No, my lord, assessment, my lord. Assessment, my lord.
Fine,
Yes, my lord.
fine. But where is their approval for you to accepting those? Because page 99, a copy was never forwarded to the authority. So they can take the plea that we are in the dark. Next page you will find. Deputy Commissioner,
Income.
Director,
My lord, approval of that.
So
Yes, my
I
lord.
just want to understand whether you could have unilaterally proceeded to issue this notification after the estimates were submitted to the government or through the DEO, or there was a requirement that they should respond back and then you issue this notification. Just clarify on that.
Malad, in between, Malad, there is a response from the Malad defense estate officer saying that the matter is under consideration, my lord. There is a correspondence from the DO to the Deputy Commissioner, my lord, regarding my approval, my lord. My lord, I've just checked the record, my lord. I find one communication, my lord.
Yes, just show us that.
My lord, Lordship may kindly bear with me.
Just one sentence, my lord.
Hmm.
Subsequently, all these notifications were withdrawn by the state government.
This notification, then fresh notification was issued.
No fresh notification, no, for withdrawal notification also. All these are, all
Withdrawn.
notifications are withdrawn by the state
Fine.
government.
Because, but their rights got infringed. They were delineated from the land. They could not access their land thereafter.
There's a communication from the Deputy State Officer. I'll let the field- Yes, my lord. It's a 12/10/2018, my lord.
12/10/2018.
Yes, madam, from the Defense State Officer Jorhat.
Is it on
Sarkar,
record of
Jorhat.
this proceedings?
My
Is
lord,
it
I
on
have the
record of this proceedings?
My lord,
Is it a
record was
part
called
of
for
this
my-
file?
Yes, my lord.
Which one page? Page,
I'm sorry, my lord.
which page it is there?
No, my lord, that will not find in the, neither in the writ petition nor in a petition, my lord.
Okay,
Because,
what
my
is
lord,
that
I
document?
called the records, my lord, originate, my lord.
Ah, okay, fine. What is the record? What is,
Yes,
what
ma'am.
is there?
My lord, it says, my lord, it said, Defense State Officer informing the Deputy Commissioner, my lord.
Ah,
My lord, it is intimate that board proceeding of the board proceeding of boards of officer for acquisition of 1,766 acres is under progress with Army. This office has already provided the LA document provided by ADC Highland for 20 rights rate for completion of board proceeding for obtaining necessary sanction. My lord. This is still awaited. This is the communication. So, my lord, process was going on, my lord. So there was the process was continuously was going on, my lord. Now, in the meantime, my lord, now 2018, my lord. Now, my lord, after entire exercise, it was handed over to the state officer for further course of action. Now, my lord, in between, my lord, 2019, I think. Yes, my lord, 2019, writ petition was filed, my lord, WPC 480. My lord, same ground, my lord, for not paying the compensation, my lord. There is a directive from the Honorable Single Court that within 3 months, my lord, the central government, they should deposit, my lord. Perhaps against this, my lord, they went to my lord, division bench, my lord. Now, further development happened, my lord, that was not brought either to the division bench, my lord. Now, my lord, there is a letter from my lord, district state officer, letter dated 25/4/2019, my lord, asking the state government to, my lord, recall the notification, my lord.
that is subsequent. That is subsequent.
Subsequent.
19.
Yes, my lord.
We are not on that. Now, you say that in
No,
2018.
my lord. That was, my lord, before passing of the land single bench order, my lord.
That was not brought to the notice of the.
Yes, my lord, not even to the division bench, my lord. Now, based on that, my lord, 11/9/2019, the state government, they withdrew the notification, my lord. So
Now,
that
what
was
is the-
perhaps,
What happened to the land? What is the status of the land that you
but
acquired?
the land, now, my lord, land is still, my lord, under their position, my lord.
Under the possession of the petitioners.
Depends, my lord. Yes, my lord. They have not vacated the land, my lord. That is the problem, my lord. Now, my lord, another question will arise, my lord, after so many years, my lord, right from, my lord, 2011, if you see the records, my lord, there is a communication constant, my lord, from the army authority asking for, my lord, this land, because this was, my lord, for security purpose, national security, my lord. So that's why my section 41 was applied, my lord. Maybe because of that, my lord, that slide, my lord, before amount was, my lord, deposited, the final notification was issued, my lord, with anticipation that they will, since they require it, my lord, for defense purpose, definitely then compensate, my lord.
That is
And there is
why,
also letter from the,
so if can I understand your submission to be of the effect that, yes, there was a requirement for them to come back to us with a sanction, but
My lord.
being given the national security perspective,
My
we
lord.
proceeded with the matter is likely to be needed, with incorporating that words is likely to be needed, and we issued the
Yes.
notification under 41.
yes, my lord.
Your second submission is that the land purportedly possessed by you is still not a government land because it's still in the possession of the petitioners. Not the petitioners, but
But
the person represented by the petition.
my lord, now, my lord, what's my lord, that notification issued, my lord, 11/9/2019, my lord. Yes, my lord. Based on that, my lord, is not our position, but is position under the army authorities, my lord. Not even the petitioners, my lord, because they
This
have not
land.
vacated, my lord.
This
Yes, my
land
lord.
is with the army.
Yes,
or
my
the
lord, they cannot
petitioners.
deny, my lord. Yes, my lord. I have the photograph also, my lord.
Army is
Army
occupying that land.
cantonment buildings are there. Yes,
The same very land.
yes, my lord.
Sure.
Yes, my lord. It was never in our possession. That's what
No, is army occupying that land?
No, we have occupied very minor portion of land and we have been paying rent. That is only 2-3 acres. All these are proposal, but these also sitting here. for
Your
your-
lordship may kindly ask, my lord, whether they have vacated the land or not, my lord.
Who? Who? Army or the
The army
petitioners?
authority, whether, no, but
The
army authority have
authorities'
the
response
vacated
is
the
that
land.
they are
my lord.
only having 2-3 acres of land in their possession. What
My
does
lord,
your record,
then
state
my lord-
record says?
My lord, then again, I have to re-verify with the deputy commissioner, my lord, then, my lord. Because as per the notification,
paying
it's
rent.
different, my lord.
We've been paying
You're
rent.
paying rent to whom?
We are paying rent to, that is, I have.
Who are you paying rent to?
The landowners.
Show me.
Yes. Affidavit of position.
See page 120 for a moment.
120?
120 of my petition. 120. See, it is for general information to all the landowners of so and so. District government has issued gazette notification of so and so for under urgency clause as schedule given below for established. Therefore, expiry of 45 days post notice, all the land notified under given is taken into possession of the government. Henceforth, no person shall carry out the kind of activities within the notified land. So all the lands for possession has been taken from page 120 onwards. 120 on 122 onwards and 123. Today, all the possession has been taken over. That's
No.
the stand of, that's what
They-
notice under 21. And kindly see, my lord, copy kindly see, for a moment kindly see 122, 121, kindly see, my lord, 121, kindly see 121. See 121, my lord, 5, see 5, my lord, 121.
120?
121.
Fine,
copy.
I've seen it. It has
Copy
been
to
said.
Defense Estate Officer. All it has been given. 122 also, Defense Estate Officer, POA holder. 123 also, Defense Estate Officer. My lord, this has gone to such an extent, and today they are saying, no, we don't require it all. So what, now, my lord, the stand of the government is that they have taken over the position. That's in the affidavit. Filed by the
He has
government
said that
itself.
from records now.
His record, they have taken over the position. And what they are waiting for the compensation to be given by the army to us, to the government, and thereafter to us. That stand taken, my lord, affidavit in opposition of, on behalf of respondent number 8 and 9. At paragraph 10. That with regard to statement made in para 9 of the writ petition, answering the same agreed as a matter of fact on record. Letter written to Defense Estate Officer so and so.
Okay,
Your
Mr.
Lordship asked
Dole,
me
you have said that you are paying them rent.
Yes, page
Where is-
33 of my affidavit in opposition.
Or first one or the second one?
Second one, page 33.
Page?
33, my lord, NXRE. My lord, you.
But one
is with
second,
me.
my lord, before my learned friend starts his.
No, I have not
argument.
started, just
No,
that.
when you, I said when you start arguing. I didn't say that you have, when you start.
No, it's okay, Mr.
My
Go,
lord,
good.
I'll just, because your lordship is now on a notification which is issued by state government 41, likely word, your lordship is on likely. I think there is one judgment of the Supreme Court. It has cleared. What do the intention of that language?
That language.
Yes, kindly see, that's my lord, 2010, 13 SCC 98. That we have given that list also.
Party's name?
2010,
Party's name?
13 SCC, party name May George versus Special Tahsildars and others. Only one paragraph I'll just read, my lord, paragraph 25. If your lordship, 25, lordship will kindly note down 25 and 28 of that judgment. Judgment. Yeah.
No, because this court, we don't have the books and I somehow left this also back, that
My
thing
lord,
also.
your lordship will kindly note down of the
I've
judgment
not noted
25 and 28, not only 28, 25.
25 and 28.
28. I just read one paragraph.
Hmm.
I just read one
Yes, yes,
paragraph,
yes.
25, my lord.
2010, 13 SSC.
I said again. 2010, 13 SCC page. That point will be cleared, my lord. Lordship got it?
Yes, yes.
See paragraph 25 first. The law on this issue can be summarized to the effect in order to declare a provision mandatory. Test to be applied is as to whether non-compliance with the provision would render the entire proceeding invalid or not. Whether the provision is mandatory or directed depends upon the intent of the legislature and not upon the language for which the intent is protected. The issue is to be examined having regard to the context, subject matter, and object of statutory provision in question. Court may find out as to what would be the consequence which flow from construing it in one way or the other, and as to whether the statute provides for a contingency of the non-compliance with the provision, as to whether the non-compliance is visited by small penalty or serious consequences would flow therefrom, as to whether a particular interpretation would defeat or frustrate the legislation, and if the provision is mandatory, act done in breach thereof will be invalid. See para 28. In fact, the land vest in the state, now important, the land
Got it,
vest
Mr.
in the state.
Because you didn't have take trouble. I've read it.
Your lordship.
This is what you were pointing out that day.
Yes.
This is under 17.
Yes, that's why likely I thought of covering this by judgment.
Mr. Dole.
Yes, page 33, my lord. My lord, you is with me. Can I ask him to sit nearby?
Please do so. Please do so.
Because he's having the records. Page 33, my lord.
This is with regard to that hiring part.
Yes, my lord. This is from page 30.
Can I interact with the
Yes,
defense
sure,
estate
sure, my lord.
officer?
Yes.
Please come.
Please come.
Now that there is some vagueness in the factual matrix as it proceeded. So we wanted to have a talk with you. Now, once that estimates came to you,
Sir.
maybe you were not there, somebody else was there, but it's your office. What did you do with that estimates?
Actually, lordship, once the approval in principle comes, after that we start collecting the documents. We take the cost from the state authorities to make a cost analysis, whether it is on as per the provisions or not. And we do a preliminary survey as well, lordship. so that we can know the real extent of land available. So
That for that you have the joint survey done.
yes, sir.
Then you
Yeah.
have the estimates submitted.
Yes.
After the estimates were submitted to you, what did you do?
Then we compile into
I don't want to what you do, but
Yeah.
what did you do in this matter?
Yes, Lordship. So once we get all the documents required, Lordship, then we compile it to board proceedings. And in that board proceedings, the representative of DO, representative of army, as well as representative of state government put their signature. And then the complete board is forwarded through the hierarchy to the ministry, Lordship. So if there are certain queries in between, before reaching the ministry, Lordship, they ask us to clarify it. So again, we clarify the observations. Finally, once it reaches the ministry, Lordship, then if the ministry finds it appropriate, then they give the final approval. So final sanction is given. So the sanction comes with the cost also, Lordship. And he also mentions that who will be the appropriate government for the purpose of this much for this acquisition. Once we get the final sanction of the ministry, then we write to the concerned DC that please find enclosed here with the final sanction given by the appropriate authority, that is the Ministry of Defense. So you are requested to initiate the acquisition proceedings as per the relevant act.
So the government having initiated without your that approval, the government had instituted in this matter the process without your approval coming on record.
Yes, yes, Lord.
But you had around 4 months time in between, right? Was the board convened during this 4 months before the section 40 notification was issued?
Board was convened right after the in-principle approval was obtained.
No, after the receipt of these estimates.
But
this-
that's in the meantime, sir, this Lordship, this board was not sent to the ministry.
That is your default.
No, Lordship, because the army was did not completed everything.
Let me understand. First, there is a board.
Lordship,
Board takes a call that we want land there.
yes.
Then you write to the deputy commissioner, give us the cost. We'll put it simple with other documents. Once you get it, does it go back to the board or does it go to the ministry?
It once we get all the documents, Lordship, we compile in the form of board proceedings, and then we send to the ministry.
Ministry. Did you send this proposal to the ministry?
No, Lordship.
Why?
In this case, proposal was not sent.
Why?
Because-
Did you inform the authorities at that point of time before the section 40 notification was issued that please don't proceed? We don't want this.
We did not.
Why did you keep it with you?
We informed the DCs that please don't go ahead with the acquisition proceedings.
No, you had around 4 months time before they proceeded.
No, Lordship.
They proceeded in the
In
matter.
2016 itself, the then DO wrote to the DC that without the final.
No, forget 2016.
Lordship.
This documents that you sought for on 7/2/2017 was compiled and a report was given to you on 17/3/2017. The notification which the state now says because there was national interest involved, so we were slightly active, more active. This was issued on 27/2017. Within this 4 months, what was the step taken by you in the matter? 17/3 to 27. What did you do?
Lordship, most of
Sat over the matter?
in most of the cases, Lordship, it takes time.
Show
Because
me what did you do after you received this? Because see, certain people have been kept out from the land. From 2017 onwards.
Lordship, but we were merely collecting the documents.
Promissory estoppel, sort of a legitimate expectation, promissory estoppel, it's not applicable, but those concepts, they suffer.
Lordship, but
Now tell me,
army
what did you do? Why did you sit over the matter? Just to understand.
means Lordship, many a times what happens that there are so many institutions involved in the whole process, Lordship.
No, you said once you received this, you convert it into a board proceeding and you sent it to the ministry.
Lordship.
Why was that step not taken?
Actually, Lordship, this goes through both the channel, through the state channel as well as the army channel. This proposal, justifying their demands for the additional acquisition or a fresh acquisition. So in this case, Lordship, I guess some time was taken. Means exactly, I don't know, so Lordship, what was the
You have
reason?
your records, check up after you received this, what did you do? If we find that you were sitting over the matter and basing on the in principle approval and all those things, the state bona fide acted. And because of that, certain people were inconvenienced, divested of their land. So they're cultivators, basically.
But Lordship, we never means forced anyone to do his work.
I'm not on the question of forcing. I'm the question of a perception being given. Now, if you have given them a perception, because it's between two governments, and because of your non-compliance with the proceedings, why should people suffer? So you show me that you acted in the matter promptly, you did what is to be done, and thereafter you told. Because by the time you told him, told the government, it was in 2018. These notifications were already out. And within 45 days, they were also asked not to come there. Kindly check your records and let me know.
That's
Yes. And another thing, Mr. Officer, I forgot one thing, one more query. Now, Mr. Dole says, and the authorities have also come up and said that that area is still under your occupation.
no. Actually,
That's the state saying, state's record saying.
no, Lordship, actually before acquisition, 2 pockets are under us under hiding. So those 2 pockets are under occupation, which hardly amounts to 2 or 3 acres.
This entire area is 177.673. Beyond this 2 acres or within this 2 acres?
So this acquisition was proposed with those 2 pockets also,
2 pockets inclusive.
where we were occupying under hiding.
So Ranford, my lord, you asked Lordship asks. So page 133, my lord, how we have.
Mr. Dole,
Yes,
I
sir.
get an impression, I don't know why,
Yes.
that there was some mistake made by some officer somewhere, and now everything is being tried to be covered up. Is that the impression? Should I draw, or I'm on a wrong footing altogether?
No, my lord, actually, what happened, what is the present position in especially this border area? My lord, sometimes when I have a discussion with my.
I got it.
Officials,
Your
sometimes
strategic
they are not
importance
sure
may,
also.
location may change.
Yes, location, whether it is in China or it is in India, that kind of situation also has
That
come
we
in.
understand.
Because it's a very high altitude, my lord. And these land 177 acres, most of the lands is not useful at all. This very high altitude. This is a borderland, my lord. And the possession where this DO has taken, or army has taken, for that 2-3 acres, the rent had been paying, my lord.
Still being paid.
Still being paid. Still being paid, that is from page 33 to my,
We have
all
got-
these money receipts are given here. So land is not in the possession of, this is possession of the petitioners, my lord. Still they are enjoying the lands.
Who is appearing for the land management department, Mr.
My lord.
Have you got your records?
My lord, yes, my lord, record in the sense, my
Do you
lord.
have the proceedings before the issuance of this notification dated 27/2017? Officials.
No, my lord,
note
that
sheets.
is, record should be, that record should be with my senior colleague, my lord. Because
Mr.
he is
Navam.
representing the deputy commissioner,
Okay,
yes.
Mr. Navam, what are the note sheets leading to 27/2017? What is the satisfaction drawn? Why was it rushed into?
My lord, first is that requisition, my lord. Lordship, we only got it requisition, my lord. Yes, my lord, requisition dated, my lord, 13/12/2016 by date. I'm sorry. It's a requisition sent by the DO to the Deputy Commissioner on 13 till 2016, my lord, asking for the areas and the joint verification, my lord. Well, I have that records, my lord.
Fine.
Then-
Joint verification done. Then,
Done. Then it was sent to DO, my lord, for further course of action with detailed estimate, NOC, everything, making the land totally free from income variances, my lord. So that, my lord, without any, my lord, objection, the board can approve, my lord. So entire document, whatever they showed, my lord, you not be only Paris, my lord, is from A to F, my lord, documents they needed, my lord. So we have sent everything with estimate cost, my lord. As my lord, the army officer rightly said, my lord, it is the board has to, my lord, take a my lord, overall view, then send it for the final approval or sanction, my lord. Well, approval means sanction, my lord. So that part was left out, my lord.
so now for that and the suffering, consequential suffering from 2017, these people last 8 years, 9 years, these people are out of the land. Who will compensate them?
My lord, now, my lord, 2017, my lord, we have hand over the land to the army authorities, my lord. Now, my lord, kindly ask them.
Show me
when
that,
did the
show me that
vacate-
handing over document, any document with
My
regard
lord,
to
there is
handing over.
nothing like that. No, my
Then
lord, there is nothing
how
like
can we
document.
presume
Once
handing
final-
over?
My lord, once final notification is published, my lord. So that land, my lord, what will do, my lord? Obviously, my, I'll give it to the army authority because it's
Okay.
a national emergency was there. my lord.
So land was done under the provisions of the 2000.
Section 41, my lord,
2013,
2013, my lord.
13. Land acquisition, land.
Law Act 2013, my lord.
It was no year. আছে নাকি 2013? না, না, এই তো হলো। Now, Mr. Nawam, we
lord.
understand that you were thinking in the national interest. Now, if you come to section 40,
Yes, my lord.
right,
Right, my lord.
you have acted under 41,
Yes, my lord.
right? For
Correct,
the
my lord.
purpose of 42,
Yes, my lord.
then how can you ignore 43?
Mala 43, there is a letter from the Mala Deputy Commissioner asking for Mala that 80% deposit also, my lord.
You could not have, because this
Yes,
is,
they-
says before taking possession, under subsection 1 or under subsection 2, the collector shall tender. Now, without the money being in the possession of the collector, why did you
My
proceed
lord.
with this?
Mala, right in the beginning, I've said, yes, they have, my lord, overlays, Mala, some portion of the Mala section 40, Mala. Yes, Mala. But
No, no, no.
in good faith, my lord, because it was a national
It
security,
cannot
my
be
lord.
good faith. Even if your bona fide faith will not do, because this is the requirement of the statute. Can you
My lord.
relax
Absolutely.
this? Is this relaxable? 43, is it relaxable? So if you did not have
Well,
the money, why did you proceed with that?
My lord. My lord, suppose, my lord, if 80% is not deposited as per section 40, subclause 3, then, my lord, the alternative is, my lord, full and final payment, my lord, with interest, my lord. So this was not deposited. My lord, when assessment was
That's
sent to
why
them
I'm trying
with
to
all the
link it up
documents, my
with
lord.
the stand of the government that when we have not given you a sanction, what made you to go ahead?
Yes, my lord, that part, my lord, there is a mistake, my lord, with
So
anticipation.
tell me
my
how
lord.
this can be remedied today. You make the payments, state, let the state make the payments.
Remedy, my lord, assessment was never, my lord, rejected or, my lord, they have never rejected the assessment sent
That's
by
it.
the
They have
Deputy
not even
Commissioner.
given you a sanction for that. You proceeded. The poor
But-
petitioners, they could have enjoyed their land till now.
But what they are saying, my lord, in principle, my lord, the government, India, Minister of Defense, my lord, they have asked for acquisition, my lord. Same way, my lord, same logic, my lord. In good faith, my lord, since, my lord, the land was required for national defense purpose, my lord, in anticipation that they will approve, my lord, sanction the amount, my lord. Because entire procedure
So
complete
do
as
one
they
thing,
wanted, my
do
lord.
one thing, do one thing.
Now,
Show your bona fideness to the government of India. Get an ex post facto approval, pay them.
Now, my lord, another things, now 2017, we say, my lord, once final notification issued, we hand over the position to the army authority. Now they are saying that it's not there under position, my lord.
Okay,
Lordship may
let's
kindly
come
ask
to
them,
that
my lord,
final
when did they vacate
notification.
the land and when they hand over this land to the deputy commissioner, my lord.
Let us come to that final notification at 118. Right?
I've seen, my lord, the language, my lord, yes, my lord, I agree, my lord.
Hundred and 119,
My lord, 99
then
also, my lord.
120,
Yes, my lord.
right? 123, 22,
123 will be different, but 22,
so 23 is different.
23. Yes, my lord.
22. It's so and so, 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 so and so. That on expiry of this so and so.
45 days
notification, all the
notification,
land
land be
notified,
notified, given schedule
is
be taken
taken into
possession for
possession of the
government.
government.
My lord,
Henceforth, no person shall carry out any kind of activities within the notified lands. Now, this
My
copies
lord-
were given to you also. These copies were given to you also. How did you respond?
yes, my
to
lord,
this?
this state officer is there, my lord, serial number
How
5.
did you respond to this?
Sir, we wrote back to the DC.
Where? Where is that communication?
It's 16.
Page 120. It'll be page 120 onwards, Mr. Das. Right?
120.
So what was your, you received a copy of this?
Sir.
What did you respond? What was your
Immediately,
response?
sir, we wrote to the
On which date?
state government.
When? Mr. Das, let's see how the things jigsaw puzzle finally comes out.
Once your lordship is asking them regarding my learned friend Ravam also, the effect of what will be the effect of the 41, 43, 41, 43, 80% will be paid. Suppose some amount has been paid, then what happens if they want to?
Because I
if they
don't want
can
to
withdraw,
proceed in that line at this stage because
this-
it would may lead to a declaration from this court that the accusation was bad.
but
But I don't want to reach to that level.
Now, my lord, your lordship today, by virtue of a judgment of the Supreme Court, they can't say, or nobody can say the accusation was bad.
No, I'm not on that.
No, that's what.
I'll
now-
come to the position.
Yes.
I want to know how the persons involved were acting in the matter at that point of time.
Yes.
That's what I'm trying to find out.
So,
So you don't have a copy of that notification of 2041-40 bracketed 1 notification, but you have a consequential notification of 8/9/2017 received by you. What did you do?
Lordship, I have just got a letter written by the Director cum Joint Secretary of the Land Management Department, Government of Arunachal Pradesh to the DC Anjaur district, where he is written that in reference to D.O. Jorhat letter, I am directed to convey the approval of the government for withdrawal of notification number LM02/.
What is the date of that notification?
9/8/2017
9/8.
for acquisition of 118.83 acres of land for army located at 7.
Can I have that copy? No, this is 19, Mr. Consul.
Yes, 19.
We have this, 19. I want to know what did you do after you received this 8/9/2017? This is 2 years down the lane. We'll reach there. I'm still in 17. What did you do? Because at least by this, you knew that you are being saddled. I'll use that word. With unnecessary burden. What did you respond? How did you respond?
We'll just check.
19, we know what you have done. And for that, Mr. Das has already placed a judgment. Mr. Nabam. Mr. Nabam.
my lord.
After these letters, notices at page 120 were issued and copies given
Yes.
to the defense estate officer, is there any response on your in your record from the defense estate officer proximate to this? We don't want a response of 2019. We want a response proximate to this. Is there anything?
My lord, I have to check the record, my lord. Yes, I'll
Please
check.
do so. Please do so. If they have not, we'll go by the principle of tacit approval.
See, the judgment of the Supreme Court by side, they see kindly, 1996,
1990.
3 SCC,
3 SSC.
phase 1,
Page 1.
phase 1.
Para?
See para 12 and 13.
The provisions of section so and so.
Section
similar to
4 of
section so and so.
52 are somehow similar section 17 of the Land Acquisition Act 1894. Just as publication notification under section 52(1) vests the land in the state free from all encumbrance provided by section 52(4). Similarly, when possession of land is taken under 17(1), the land vests absolutely in the government free from all encumbrance. A question arose before this court that if there is non-compliance with the provision of section 5A and an award is not made in respect of land so acquired, would the acquisition proceeding lapse? In Satyendra Prasad Jain versus so and so, once possession has been taken under 17(1) and the land vested in the government, then the government could not withdraw from acquisition under section 48, and the provision of section 11A were not attracted, and therefore the acquisition proceeding would not lapse on failure to make an award within the period prescribed therein. It was further held non-compliance of section 17(3)A, which is parameter 43, regarding part payment of compensation before taking possession would also not render the possession illegal and entitle the government to withdraw from acquisition. The aforesaid principle has been reiterated by this court in so and so. In view of the aforesaid ratio, it follows provision of section 11A are not attracted in the present case, and even it is assumed award has not been passed within the stipulated period, acquisition of land does not come to an end. Now, para 13 is important. Para 13, because there is a parameter clause so far Rajasthan Act is concerned. Kindly see 13. It was contended by learned counsel for respond that the state has complied with all the legal requirements in the present case. Our attention was drawn to section 60A of the Amending Act and Validating Act, and it was submitted. And in our opinion, rightly, that subsection 3 of the Amending Act and subsection 4 Validating Act only require the making of the award and payment of money within the period stipulated therein. The facts narrated herein above show that this was done. In any case, non-compliance or with the provision of this subsection will not in any way affect the vesting of the land which has already taken place with the publication.
That query that I had raised, that is answered here.
Yes.
No, now the issue here is beyond that. Issue here is there are two authorities. The state and the requisitioning authority is the Union of India. Now the state had done it on behalf of the Union of India. Now the Union of India is now trying to project, we did not give a sanction. To issuance, for issuance, we wanted that land. Exercise was on. So now if the Union of India has not given a sanction, they have withdrawn their thing. Now without ascertaining their role or the act, can this court direct that, no, you should pay. You should pay. If the responsibility cannot be saddled on the Union of India. That's why I was trying to
But your
examine,
lordship, that's not only,
because see,
they cannot now short their political responsibility.
because see, what they're trying to do is,
See, my lord, we are whether it is union or whether it is state.
no, there
Number
is a
one.
difference, Mr. Das. That's
Yes.
why I was trying to take you
Yes.
through that steps.
Yes,
Now, once that estimate is prepared, and a totally absurd estimate is prepared by the deputy commissioner, see, a situation, and then the requisition authority is required to meet that. It may not be a position envisaged by the act. So it is sent to them for an approval. Now, that approval, nothing had come back. It has not reverted back. The state rushes in and issues a notification. That's why I've been asking Mr. Nabam, what led you to issue that
now, my lord,
notification?
I have also noted down one thing. One, the notification was issued, one. Secondly, position was handed over. It was.
That is
informed.
now.
Now it is informed to the defense asset officer.
Mr. Das, that is exactly what I'm trying to do. The notification under 41 was not sent to them. But the notice at page 120 onwards was sent to them. I'm trying to now find, because at least now they have knowledge.
Yes.
I'm trying to find out as to how they reacted to
Now,
this.
whether once you get that notice under 21, that this position has been taken over, copy to all the concerned defense asset, immediately they should have reacted, said that no, how will notice?
Then the remedial action could have been taken by the state immediately.
Now even then for a moment, remedial action should have been taken immediately by the state. Then also the state cannot run away from the absolve.
That is for
Well,
the state.
that's the one aspect of matter.
That would be an issue then.
But
Who would
once-
be saddled with the
But
responsibility?
once the Union of India knew about.
That's
that
what I'm trying to
21,
find out.
They could have immediately replied to the authority.
Say we
that,
did
sir,
not give you a sanction. Please don't proceed. You have proceeded at your own peril. And the words likely to be needed.
But likely to be needed is now again.
No.
interpreted by
In
the-
this context.
No, in this contract, only I am showing that.
I know that, Mr. Das.
Yes.
But here, when
Yes.
therein there was nothing.
Yes,
When they say that we have not given a approval to your estimates, that
yes,
likely to be needed
yes.
assumes some importance. Yes, you have got it.
No, sir, nothing for now.
Huh?
We are not able to get any response to that notice.
Why?
Because we have not, in record, Lordship, this notice is also not found. This notice, Lordship, we could not find in our.
It's getting murkier. We'll direct for a inquiry in the matter. We don't want them to be enriched illegally, and we don't want them to be deprived illegally. Either way. And if this is the state of affairs, we'll direct for an inquiry by a competent body.
This notices are not, copies are not sent to.
That marking is there.
Page 99.
We have not responded to the post.
Actually, this was not sent.
Page 121.
Page 120.
120, 121.
Notice was, it has been marked, copy was marked.
What is this letter number? Army Part LM HLG LM05. Have you got a copy of this notification at page, communication at page 127 addressed to you? 21/8/2018.
127.
Letter is also not signed. You just check lots.
Okay, Mr. Das,
Yes.
let them make that examination.
Mm.
Now thereafter, the deputy commissioner as well as the petitioner herein started approaching the government,
Yes.
saying that kindly expedite, release the money, all those things. And then
Various representation was filed.
various representations were made.
Yes.
Okay. And then what
Nothing has been
happened?
done. So we filed a writ before. this
We
court.
five, you came up before this court.
Actually, my.
And
lord,
this
when we-
court allowed your writ petition.
Now, my lord, the writ petition, once it was allowed, because said it is 41. So we don't have to go into all intricacy, because one document may be very relevant in this case, where your lordship, my learned friend already helped out, that what is the role of a defense asset officer in respect of following all the procedure?
Now, show me that first, before that, show me that in principle approval. Is it available on
Yes.
record?
Finally, the affidavit kindly be. By the- See the affidavit.
Affidavit filed by the,
DEO. 124. That is-
dated 8/7.
dated
11/7.
31, 2019.
30.
1, 2019. Kindly see page 13. Lordship got it?
The records are not maintained.
Lordship got it?
No.
Page 13,
Page 13.
1-3. Reference, headquarter letter dated so and so. In principle, approval of Honorable Raksha Mantri has been accorded for acquisition of 200 acres of private land at so and so, so and so. Board of Officer conveyed for preparing the border proceeding for obtaining a section of the Government of India for acquisition of above mentioned land will adhere to the following: assess whether the entire land projected to be acquired, examine whether the entire requirement of or part thereof can be met through current holding of difference, so and so. The recommendation of the Board of Officer will specifically indicate above mentioned points have been complied with. So this is the first letter.
But again, Mr. Das,
Yes.
this is not a final approval.
No, this is right.
It's
No,
only,
that cannot be.
you only go ahead.
Yes, right. In
Again, it
principle.
boils down as to whether that estimate required a sanction
Yes.
and thereafter the government should have issued.
This is in principle approval. So I am not saying that it's not final, but one letter is very important, my lord. For a moment, kindly see this. All this which your lordship has said, this A, B, C, D, all the procedure, then it has to be sent, then it has to be sent. This is not done in respect of 40 or 17(1). It is only done in respect of 9 and 13.
No,
9 and
41,
11.
see, they never asked them to do it under
No,
41.
right, kindly see. kindly read.
41 is a measure as adopted in the matter by the state
So
government.
that is why, what normally the intention registration, if it is 41, 41, there, if there is no award also 80% has to be paid. This is a intention register. Why? Because the people, their landowner get displaced. Then landowner get displaced, so 80% at least it is given to them. Now see, this is my lord. Acquisition, what you got it? Defense Estate Department is a nodal agency for acquisition of land for services and other defense established in Army, Navy, Air Force, so and so. after in principal approval is given by Ministry of Defence for a particular project involving acquisition of land, a board of officers conveyed by the local military authority for formulating the proposal. The board of officers is advised by defence estate officer on the cost of land and asset as well as rehabilitation and resettlement aspect. Ministry of Defence issues sanction for acquisition on the basis of recommendation of the Defence Estate Department. On receipt of government section, DEO places demand upon DC competent authority for
That's it.
acquisition of land.
That's the missing link here.
That's what, father is important. He licenses with the land acquisition collector, state government to expedite publication of territorial notification under relevant Land Acquisition Act. Now important, DEO is involved in the proceeding under section 911 of this act and justifies the basis for the rates adopted by government in respect of the proposed acquisition. So this is only in respect of 9 and 11. So 40 is a case
This
of
is just
urgency.
a general,
No.
this is just a
see down
general.
below.
You show me something with regard to 40 then.
Then see
Similar
further
provision
down
with regard
below.
to 40. Ah.
Milo, you don't have to show. When it is 9 and 11 has been stated here. So 40 will definitely not. Milo will go down below. Go down below on the
I've got it.
last. It's a Milo, it is on government, it's Directorate of General Defence Estate. I will not show something which is.
I know that.
not so-
But to draw a presumption to that level,
No,
basing on this document,
No,
may
these
be
presumptions-
difficult.
No, I am telling you, Lordship. 9 and 11. So that is specifically it has been mentioned. The 9 and 11 kindly see. So, my lord, I am respectfully submit before Lordship that 40 is something different to this.
Mr. Das, you need not reiterate that. We have understood.
Yes.
But the question is whether the union had given its approval to issue that notification.
No.
Now, here we are now, we are coming to that situation
Yes.
wherein it is crystallizing to the effect that without the approval, the notification was issued. Likely to be needed. Now, that is a notification act. Mr. Nabam has also said that there was a mistake. Now, let me,
That
let
mistake- No,
let
if
me,
Your Lordship has read page 99, only second paragraph. Third paragraph, your Lordship will read it.
page 19.
99, your Lordship has read only the second paragraph. Kindly read the third paragraph of the notification at page 99 of the writ petition. See, my lord. See, where it appears to the governor, land is needed in urgent. Then, my lord,
We got it.
that's
But
what. my
The
lord.
question is, this notification was not issued after the estimates were approved by the defense estate officer. We are stuck at that point.
Yes.
Now let me try
No,
to
they
unlock
said it.
that.
They
Let
have stated
me
themselves.
try
No,
to unlock
I-
that.
I- Your Lordship has put a query to them. What you have done.
I-
Why you
I-
have kept,
I-
now for that, that they should be scot-free.
Will
because
not
they
be.
have been, I'm just putting myself, my lord, whether they could be scot-free, that no. They have done,
Mr. Das, I used two words further,
yes,
tacit approval.
Yeah.
It was in that connection.
correct.
Now
Right.
let me try to examine this matter from a different angle. Now there is a document on record, brought on record by you, wherein you had asked the government to cancel,
Yes.
right? Where is that? It's sometime in 2019.
Yes, my.
Mr. Fukon, where is that document? 2019? When they said that we have received the approval of the government?
My lord, in my affidavit of opposition, page 29.
Affidavit in opposition, which one?
Second
Earlier one?
Second one, my lord.
Second one.
Page 29, my lord.
That is space which I read, no, my lord, which I read and taken that affidavit in principal approval, that's the same affidavit. Same affidavit. See page 29, which my learned friend is addressing.
page 2930.
No, 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 no.
Yes.
No, 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 not this, not this, not this. There is one more. There is one more.
There's 2019 document, I think.
No, Mr. Maybe I'm wrong with the date, but there is a document wherein they said that please cancel the notifications. Because we have received an approval from the government of India in this. Where is that?
That
But
we
it-
don't have. We don't.
This
have.
is 19 also, 19. My lord, this is. This is by, no, there, internal documents, my lord, state government.
We wrote. to
Acha,
that. What's there?
there is no- Yes, yes, yes.
I think that could be, I don't know whether it is.
There is,
Let's see.
there is. When I have found it.
Maybe some government records has been shown.
No, no, no.
that day.
Here. There is a clear document. Sorry, I missed it out. When
Whether
I
they
was
can-
going through the matter,
They have cancelled it.
they say cancel it.
Where is the state? To the state.
Mr. Dole,
Yes, yes, I'm finding it.
just find that out for me. Mr. Navam,
Yes,
where is that letter by which they asked you to cancel those notifications? Yes.
Which way?
Uh, come to page, not the page 30 of the first affidavit file.
First state. First state.
It's a document from the director cum ex officio joint secretary land management department. Come to
Yes.
page 30.
Which affidavit? ma'am?
Affidavit
Where's
by
my-
the
Yes, first affidavit.
first affidavit by the one Mr. Barchaswa.
That is the second one, my lord.
Second one.
Yes. that is the
11/7/22.
Yes, my lord, that is. the
Second one. Okay, fine.
Barsua.
Bursa, he is the
Bursa.
Mr. Bursa.
There's the additional affidavit.
Yes,
Additional
additional
affidavit.
affidavit.
Additional.
19, yes.
So this is the cancellation,
Where is that? Sorry,
page 30.
30. I have not watched. Page 30.
Right?
Right.
Now, this is, if you come to the copy to part, this is based on a defense estate officer's letter
Hmm.
dated 29/4/2019. Where is that letter? 29/4/2019. That is also on record. I have seen it.
24/7.
29/4/2017. Wherein they say that we have received the government approval for cancellation. I think that is the letter. 29/4/2019. And Mr. Das, you are holding that affidavit.
Where?
You're holding that affidavit.
Yes,
Now, why the issue that an approval is required from the government
yes.
and the state government has to take an approval sanction and then issue the notification, page 27. Can you just find that out for me?
Yes, sir, absolutely. Correct.
So the state also knows that this is the procedure we have to follow. Mr. Nabam,
Yes, my lord.
page 27.
Page,
27 of the affidavit of second additional affidavit of the DEO.
I'm sorry, my lord, I don't have that second additional affidavit filed by the
Okay.
DO, my lord.
Okay.
It seems they have not furnished us, my lord. I don't have. नहीं
What is the date of page 87 notification, Mr. Fugan? That communication?
87.
Hmm.
That's a read petition. You know, read
No, writ petition.
petition. 17th March 2017.
You have got that, Mr. Officer, have you got it? Have you got it? That letter,
Our letters,
huh?
yes,
29,
29 April, got it.
right? Is it written there that you have the permission from the ministry for cancellation for something of that? What is the wording of that letter?
If it is, Lordship, in this, we have addressed to the Secretary Land Management,
Hmm.
citing that no approval has been given by the ministry. And although the DC was concerned regarding this earlier, but he has issued the notifications quo motu. So you are requested to cancel the notification. That is
That's
the main.
my lord, these are not concerned. It is them. Today they are saying they want.
No,
to
no,
withdraw.
I have to be concerned because now I'll have to say who will pay the money.
That's right. That's your lordship is absolutely correct. That's absolutely your lordship is correct. Now your lordship has seen the judgments. For that they can't say, if the state can't say or the government, I don't know about them. State can't say that no, this direction has given to withdraw it, but why you have taken the position of the land? Your lordship is right. Who has to give for the, now the.
Mr. Navam, Mr. Navam.
Yes, my lord.
After the notifications were withdrawn in terms of that letter, were the lands released back to the petitioners? Because you have cancelled the notifications.
My lord, that's why I said, my lord, your lordship, this army authority, we have said, my lord, 2017 notification was issued. We have taken the position, it was handed over to the army authority. Now, my lord, they saying that they are not
No,
under
they
the
have
position
not.
of land.
They have not. I've seen it. They have not got the position.
lord.
There are letters. What they did was, after maybe their records, they are not being able to find out, but it's there in their affidavit. I wanted the original. After they received the estimates from the, what do you call that, deputy commissioner, they forwarded it to the
Yes.
army authorities, JKF, Jeff Rifles, with a stipulation therein that, see, this is what is sent by the deputy commissioner, but we have asked for further clarifications and we are awaiting that.
Sorry, my, it's
And-
cracking my voice.
They said that it's clear now. It's clear, Mr. Nabam. Mr. Nabam, can you hear me?
No, my lord.
Some problem. Anyway, don't worry. We'll come back to you.
My lord, my lord.
See, once they receive that estimates, you have received that estimates. You have received that estimates. They forward it to the army authorities. Stipulation therein that please don't process because we are asking for further, we have asked for further clarification, awaiting that. Now, the state then rushes into the matter, issues notifications, right? In spite of the fact that it was the standing, so the deputy commissioner acted in a matter in haste, in violation of the directions issued by the secretary management long back, saying don't issue any notification without the approval of the DEO being received. Now tell me, if an officer of the state has acted in the matter on his own, illegally, can the state be saddled with that responsibility?
The state,
Compensation, it's a different issue altogether, but on a question of this
he's
nature,
a part of a state. He's a part officer.
he acted in violation of the
That-
directions of the state.
No, that is different, my lord. My learned from Nawam has to make a statement on this. I don't know how the officer.
Mr. Nawam, can you hear me?
My lord.
Mr. Nawam, you do one thing. Now the things are getting clearer that this was an act done by your deputy commissioner without authority.
My lord, I have just heard your lordship saying that although there is a direction from the secretary land manager not to act upon, but keeping aside that, my lord, he has acted with individual capacity, my lord. In that
That's
case,
it.
my lord, yes, my lord.
But see, if you come back to
Then, my
that,
lord, the concerned official is to be level.
that concerned official may not be, I'm not saying may not be in the world, but he may not be in the service. So, these two notifications, have you alleged? Can you allege or can you show that there was complicity between the petitioners and the deputy commissioner's office in this connection? Enquire. We'll permit you. Constitute an SIT, enquire. Find out,
Yes, that can be.
right? If required, we'll pass that order. If not, then you will have to take up the burden.
Well, in that case, my lord, since the my lord, secretary land management is the guardian of the land, you lordship can always direct the secretary land management to make an inquiry. Is there any nexus between the deputy commissioner or this land beneficiary or not, my lord?
But today,
preliminary.
by making that person to inquire, he will not be able to find out. This has to be by CBI.
But you lordship have to trust somebody, someone at least either judicial officer
No, I
or
don't
my
want,
secretary.
I'm not, there is no distrust on the secretary.
My lord.
What I'm saying so, the secretary may not have the means to find out this. This will require an interrogation, it will require an investigation. Secretary may not be in a position to do it. He is an IAS officer. It will require an IPS officer.
My lord,
We are
I'm
not- we are
hearing for the
just-
first time,
Broad thinking.
my lord.
Because
My lord,
the more we go into, we find that the Union of India, they could have acted better in the matter. No
Well,
doubt
before
about
your
it.
lordship passes any order,
Will
my
not.
lord, because I'm hearing for the first time, there is a direction from the secretary land management directing the deputy commissioner not to act
Not to do
upon. My lord,
It's
let
there
me
on
go through
record.
that.
It's
my lord.
there
Yes,
on
my lord. Let me
record.
take- Yes, my lord.
You have your instructions.
My lord, yes,
We'll have it on Tuesday.
my lord.
Now the position is clear. You have a discussion with the secretary, explain the position, what was transpired in the court today,
My lord,
and then Mr. Nawam advise,
my lord.
submit what we should do, right? On Tuesday at 2 p.m.
Tuesday,
Fine
my
with
lord,
you?
2 p.m. My lord.
Tuesday I will not be available.
I'll go to Alu, my lord, for a similar kind of case, maybe on Friday, my lord. As your lordship, please.
When are you going?
I am going on Sunday, my lord.
You coming back?
I'm coming back on Tuesday.
Tuesday. On Wednesday, Mr. Nawab,
My lord,
on Wednesday, 2 p.m.
my lord, Wednesday, I have some personal debate. Can it be
Thursday?
Thursday, my lord?
Thursday.
Thursday?
Mr. Das, Thursday, there is no problem.
There is a problem, slight problem. It can be on Friday. It could be.
Friday, 2 p.m.
Friday, my lord. All right.
Friday, 2 p.m.
इसको xerox करना
Kindly
पड़ेगा।
get hold of those documents. Please do some exercise. We don't want the public exchequer to be unnecessarily burdened. At the same time, we don't want them to be also.
My lord, there is another, my lord, problem, my lord.
Uh-huh.
The affidavit filed by the central government, my lord. We don't have any copy, my lord, so we are not able to assist the court, my lord. They have not served us the copy, my
We
lord.
will try to,
My lord, Mr. Kamduk is having that copy.
Mr. Kamduk is having.
So they can make a
इधर है,
photocopy. Land management.
इधर है।
You give Mr. Kamduk, you give Mr. Nawab, assist Mr. Nawab.
Yes, my lord.
I've been asking my friend, my lord, whether he has affidavit or not, my lord.
It has been furnished to
No,
me.
he may not have understood. Mr.
All right.
Nawab, take possession now.
My
51.
lord,
Take possession
my
of
lord,
the affidavits.
my lord, both, my lord. दो affidavit filed, they have filed two affidavit.
From 2018. Your lordship will express the difficulties of our we have faced.
Mr. Das, with this material before me, if it was some other matter, I would have dismissed the repetition by now.
ये क्या है?
But it's a
LCD
matter wherein the rights
Central
of the
government.
persons have been snatched
Is
away.
it Korak
Mind
or-
my words, snatched
Yeah.
away.
I don't
My
know what
only endeavor is to see whether there is a tacit approval from the
Central
government of
government
India in the.
Telling
If
for
I
it,
find that there is a
petitioner है।
tacit approval, I'll pass orders, saddling them with the responsibility. But if the more and more I go, I find that they are not at fault. The state is not at fault. It is the deputy commissioner who is done all these things. Then I'll have to have a satisfaction drawn as to whether there was some nexus between the petitioners and the deputy commissioner in the matter.
And section 40 also, the commissioner invoked without having the power, my lord.
That's it.
My lord, we have not received the affidavit filed by the central government, my lord,
Huh?
or defense.
Yes, Mr.
We have
Raman.
not received the affidavit.
I'll ensure that they give you a copy.
Yes, that will.
Before Tuesday,
My lord.
before Friday, they'll give you a copy.
Yes.
Don't worry.
But whatever may be, my lord, there is a negligence on the part of the government of India. I'm
That is
saying to
why,
be accepted.
Mr. Das,
There is a negligence.
when I'm saying something, I may sound harsh, but it's not, I'm not harsh on anybody. I'm trying to find out.
That's what I'm saying.
And that's why I use the words. Don't forget my words. Tacit
No,
approval.
that's right, my lord. But there was negligence on the part of Union of India. From
That's what
where-
I'm trying to find
There
out.
is a tussle between whoever in his personal capacity, whether they are blaming someone, but we are sufferer. We are
That is
sufferer.
why I'm trying to find a way out.
That's what I'm saying.
If I saddle the government of India, I want to saddle them with concrete materials.
Oh, that's true. my
If I can't, I'll have to saddle the state, I'll have to saddle with concrete materials.
Now, there
Let's
are
not
cases-
be on ipsy dixit
No,
here,
but
there, that.
There are cases also in our court, we find that a particular officer is responsible. He has to pay from wherever he wants to pay from his pocket or wherever.
We'll do that.
There are cases.
We'll do that.
And if your lordship will kindly see, they are representative of the state government. They know very well. A notification has been issued by the government, by the government. That's 2017, knowing fully well. Now, their blames comes against a particular individual that they cannot absolve from that, my lord. Once a notification under 40, that's a law laid down by the apex court. You cannot, my lord.
But
Tomorrow you can't
Mr. Das, I know you're suffering.
Yes.
That has to be remedied in one way or the other. But if they are not even in any manner connected with that issuance of that 41, which now subject to the documents that they will produce, they are not connected.
No, if they are not connected,
I'm giving you three situations. They are connected, they pay.
yes.
But today we have not found materials to connect them because of the steps that the unilateral steps taken by the government here. Now, two, if they are not there, then it's a state. Still no problem. You are free. You get the money. third situation is the state nor the union, but the deputy commissioner is involved. What would happen in that situation?
In that case, if your lordship takes the third stand, there is a matter of SIT investigation. They will give a report after 10 years.
No,
then-
we will
No,
have
that's why-
we will have it within 1 month.
Suppose they may say, to the state may absolve, they shuttle that particular to one deputy commissioner. Then we are sandwiched in between. Nothing
No, no,
will
if
happen to
that be
us.
so, we'll direct the state to pay. We will direct the state to pay and this,
Today,
the recovery would be from the
today
officers.
what they are stating, the Union of India have seen that query has been put forward. That 21, notice under section 21, within 45 days, position taken over and the copy has been sent to defense asset officer. What they want to say on that?
They say now, that's why I've asked him to verify his records. They don't have that notification in their records.
Now this is what they are taking a stand in the court.
I have,
They doesn't have.
I am not disclosing further.
That's what it
Mr.
says.
Das, Mr. Fukan and your other persons can go through the affidavits. Just link up.
Yes.
You will find the steps. I have found it. I'm not disclosing any further.
I'm sorry, I couldn't.
You go through the affidavits filed,
Yes.
you will find the linking. Everything is there. But I want the defense estate officer to come up with that. Let's see then what happens. I'm not disclosing it.
Oh, that's true.
No,
Mr.
one
Officer.
sentence regarding the power of attorney, just to reiterate the one thing, my lord, the petitioners, the landholders are not before us.
You gave
So
it
that
up.
question is there, whether it is maintainable.
No, you gave it up.
Yes.
You gave
No,
it
no,
up.
Give it up means that question, my lord, that question may be recorded.
What?
Because what happened, the landowners are not before us.
Mr. Dole, other than that, what is the issue involved there?
Yes,
That
is
was the only
question.
issue.
Yeah,
I
that-
asked you 3 times. You said I'm giving up.
No, give
Now I'm
only-
not
only
going
because
into
of
back.
that, my lord.
I'm not going back to that.
Again, going back.
I'm not
That-
going back.
That is the stand I made it, madam, that may be recorded.
No, I'll not.
Uh,
Then you argue. Then you argue, tell me that why that is not maintainable.
will-
Show case
I'll
laws.
satisfy your lordship on Friday, my lord. That's the first point.
That's what, my lord, I don't
That's
understand.
Mr.
my
Dole,
point, right?
They
No,
said
no, no,
that I-
Mr. Dole, you said that point. I was
Yes,
not there. I'm not.
Only because.
You want me to replay that?
No, that is.
You
what
want
is-
me to replay your words?
No.
I can replay it.
No, my word is, my lord, petition, that I said also, petitioners are not before us.
Mr.
When
Dole,
two sentence, whether it is
Mr. Dole,
maintained.
I made a specific question to you,
Yes,
Mr. Das, that see, the petitioners are not here. Whether the power of attorney holder can come as a petitioner.
or I am not, that is, I am not, that is, I live with your lordship, whether power of attorney holder.
No,
can
I
come or
want
not.
you to raise the question
Yes.
because you raised that question before the division
That is
bench.
my question is
Division
on that.
bench.
Petitioners are not before us, whether it is maintainable. Whether power of attorney holder can file the case, that is, I leave to your lordship.
I don't understand this type of. The petitioners are not here. That is why the power of attorney representing the.
That is the
petitioner-
question.
Mr. Dole, maybe you got to reframe your question.
Yes,
Kindly do that. Because either way, because I came prepared for that issue.
yes, yes.
Once you said you gave up,
That is it.
I wanted to
That is
examine
why I
that
said
issue.
that. Let us-
That is why I troubled Mr. Das to show me. He has shown me.
Only two sentences I said.
He has shown me and the judgment of Justice D.Y. Chandrachud while he was the Chief Justice of Allahabad High Court. I think the reasoning therein acceptable. This court need not go into that. We'll say you have given it up. And
Like,
get me the documents, photocopies of all the things starting from starting after the estimates were submitted to you. Serially from your records. Because there are documents on record here. We can verify. Then how did you issue the document that you have issued to them now, asking them to cancel, right? What is the preceding office sheets to that, note sheets to that? Leading to issuance of that document, what are the preceding note sheets? Right? Kindly on the next day, make a compilation of this and give it to me and keep your records ready. And I'm not recording it in the order. It's already recorded in the proceedings. So kindly see the proceedings if there is any doubt.
One last submission, Lordship. Actually, I was just looking for the records you asked. So while going through the file, Lordship, even after the notifications were, notification was issued by the DC, and it can be inferred from those letters that the office of the DO was not aware. As we were continuously writing to the army to complete the board proceedings after licensing.
That I have already disclosed. It's there on records. I have already disclosed it.
Dark, Lordship. And
Fine.
we were trying to. complete the
Establish
board as
that.
soon as-
Establish that. And then also, you have issued a notification now, please cancel. There are two notifications, find out. One is very explicit that we have received the instructions, approval from the government to cancel this. There is a document on record. Find that out. And I want the note sheets pertaining to that. Or when the approval was given by the government, what was asked for? Do you get my point? It's not the letter. What was preceding that which led to the approval? I want that. If that demonstrates that you were in dark and this was an action by the state, we will exonerate you. We'll proceed against the state. But these people cannot be put to much trouble. Right? So there are three possibilities. One, you. Next is the government. Third, both. Then it's a DC. Then in that situation, we will have to see the complicity of the petitioners with the DC. That we will do. But first, let us negate the possibilities. Tuesday, Friday.
Friday.
Next
Friday,
Friday. Heard the parties at length. Hearing remains inconclusive. As agreed to by the parties, list this matter again on Friday next. Full stop. As required by this court, the incumbent in the post of, you are the defense estate officer. Defense estate officer who is present in the court. Full stop. As required by this court, the defense estate officer shall produce the records in the matter, more particularly with regard to the queries raised during the proceedings today. What? List again on so and so. 2 p.m.
2 p.m.
Mr. Nawam, 2 p.m. Friday, 2 p.m.
My lord, yes, my lord, right.